Good afternoon, all. On behalf of the Moot Court Association School of Excellence in Law, I warmly welcome you to the finals of the 19th Pro Bono ENVIRO National Moot Court Competition 2025. I would like to take a moment and thank the esteemed judging panel of today. It's indeed a true honor to have you all. We have with us today Honorable Dr. Justice P. Jyotimani. He is a distinguished former judge of the Madras High Court and holds a PhD in criminology from the University of Madras. A gold medalist in BGL, BL, and ML, he has received numerous accolades, including the Justices Panchapakesu Shastri Memorial Endowment, Lakshmi Narasa Reddy Gold Medal, and Chief Justice Veeraswamy Gold Medal. Enrolled as an advocate in 1975, he practiced on both the original and appellate sides of the Madras High Court, handling educational and service matters. He served as standing counsel for prestigious bodies such as the University of Madras, Food Corporation of India, and the Bar Council of Tamil Nadu and India. Elevated to the bench in 2005, he delivered several landmark judgments, including those relating to the Kudangulam nuclear power project and Google Incorporation trademark issues, and disposed of over 45,000 cases. Post-retirement, he served as a judicial member of the National Green Tribunal, New Delhi, and later the Southern Zone, Chennai. He is a life member of the Indian Law Institute, New Delhi. Next, we have with us today Honorable Mrs. Justice V. Bhavani Subbarayan. She is a respected former judge of the Madras High Court and currently serves as the chairperson of the Tamil Nadu Pollution Control Board Appellate Authority. She began her legal career in the office of Mrs. Iyer and Dolia Advocates and later practiced under the guidance of senior advocates Mr. N. Natarajan and Mrs. Ramani Natarajan. Between 1994 and 2004, she practiced in Nilgiris district courts, effectively implementing the legal aid movement to support tribal communities. Returning to Chennai in 2004, she continued her practice in the civil side of the High Court. Her legal journey reflects a deep commitment to justice, social welfare, and environmental governance. Next, we have with us Advocate Mr. Srinath Sridevan. He is a designated senior advocate of the Madras High Court and the founding partner of HSP Partners, Advocates and Solicitors, Chennai. A sixth-generation lawyer, he graduated with a gold medal in law from the University of Madras in 1990. Completed his LLM from New York University in 1997. He began his career with Allen and Overy, London, gaining valuable international experience in arbitration, mining, and corporate law before returning to India to establish HSP Partners in 2004. With over 2 decades of diverse practice, he is widely respected for his expertise in corporate and commercial laws, arbitration and dispute resolution, and for his continued contribution to the legal profession through mentorship and academic engagement. Next, we have with us Advocate Mr. T. Gautaman. He is a designated senior advocate practicing before the Madras High Court and other courts with over 25 years of experience across constitutional, civil, criminal, and corporate laws. He holds degrees in law and business laws from the University of Madras and the National School of India University, Bangalore. He has served as the Chennai Head of India Law Offices, a Delhi-based international law firm, and has represented prominent clients such as Joy Lucas, Adani Enterprises, and Jain Housing. His areas of practice include arbitration, company law, insolvency, labor disputes, and environmental matters. He is also a frequent judge at national and international moot court competitions, including the Stetson and Jessup rounds, and serves as a guest lecturer at VIT University, Vellore. Next, we have with us today Advocate Mr. Rajiv Kurinjipadi Rajamohan. He is currently serving as a legal consultant with the Tamil Nadu Pollution Control Board. He brings with him extensive interdisciplinary experience combining law, management, and analytical expertise. Prior to his present, he served as a guest professor at the School of Excellence in Law, Tamil Nadu Dr. Ambedkar Law University from 2018 to 2022, where he contributed to academic and research development in environmental and administrative law. Earlier in his career, Mr. Rajiv held senior analytical positions in the United States, including as senior business analyst at Pacific Gas and Electric Company, DT Energy, and MTech Incorporation, gaining over a decade of experience in corporate and regulatory systems. Next, we have with us today Advocate Mr. Sai Satyajit. He is the standing counsel for the Tamil Nadu Pollution Control Board. A graduate of the School of Excellence in Law, Tamil Nadu Dr. Ambedkar Law University, he enrolled with the Bar Council of Tamil Nadu in 2011. His early years of practice spanned constitutional rights, service and labor law, civil and taxation matters, and arbitration. Since 2013, he has independently practiced with a specialization in environmental and constitutional law, regularly appearing before the Madras High Court and the National Green Tribunal Southern Zone. He has also served as sole arbitrator and advocate commissioner in various cases.
appointed as standing counsel for Tamil Nadu Pollution Control Board in 2021, and later as special counsel for coastal zone map and plan cases in 2024. He now also represents the Department of Environment,
State level Environment Impact Assessment Authority, and the Tamil Nadu Coastal Zone Management Authority. Before we begin, I'll brief you on the instructions and rules. Each team has 45 minutes to present their arguments. No speaker shall exceed 25 minutes. This time includes a maximum of 5 minutes for rebuttals and sub-rebuttals. Please manage your time within this limit. Any documents submitted to the bench shall be submitted to the coast masters. No material shall be directly shared with the bench. The timekeeper will inform you by displaying time cards indicating 5 minutes remaining, 2 minutes remaining, and time's up. Researchers should not argue at any time. For this round, TC10 will be representing the appellants and TC20 will be representing the respondents. Thank you. With the permission of the judges, we shall begin the rounds.
Greetings to the Honorable Bench. This is counsel in the case of Vadakku Pradesh State Pollution Control Board and Toliyanadu State Pollution Control Board versus Bhakti Corporation and KIA. Addressing the presence of an Honorable Ladyship, the Council would like to address the benches, Your Lordships. Much obliged, Your Lordships. The Council seeks permission to brief the facts of the case. Much obliged, Your Lordships. Your Lordships, here in Union of Navalandiyam, the first dispute arose in Keeladi district, which is a part of Toliyanadu, where River Porunai has been contaminated by multiple pollutants such as industrial effluents. The reason that the expert committee has found are two different reasons. First thing being the district administration in itself, where the sewage plants were not properly constructed through homes. Secondly, the industries, there were 234 industries recognized, collectively known as the KIA. Your Lordships, the second dispute was in Vadakku Pradesh High Court, where Bhakti Corporation was involved in a similar dispute. The Vadakku Pradesh High Court has given a judgment that the SPCBs have the question, the dispute here is the Vadakku Pradesh, if it's binding on Toliyanadu, there they have said that SPCB do not have power to claim compensations. Whereas here in Toliyanadu, when the same compensation was placed forth before these industries, the industries have cited that judgment, stating it to be binding, and the NGT has upheld that. Now, much obliged, Your Lordships. There are four legal issues here in dispute. First thing being, if the High Court judgment of another state is binding on the southern state, that is Vadakku Pradesh High Court, if it's binding on Toliyanadu. Second issue will be if the SPCB and CPCB have powers. Third will be regarding to the methodology. And fourth will be about the evidence. The council will speak for 21 minutes about legal issue 1 and 2. And co-counsel will speak about issue 3 and 4 about 21 minutes, Your Lordships. With due permission, the council like to proceed with the issue number 1, which is the applicability of high courts. Your Lordship, the council would like to deal with this in two different folds. First thing referring to Article 226, Clause 2. With due permission, the council summons the compendium. Much obliged, Your Lordships. If the Lordships are with me, the council would like to proceed with the first limb of the argument, which states Article 226, Clause 2 is what the respondents have been binding on. Secondly, the Kusum Ignat's case and its obituary dicta. Your Lordship, Article 226 in itself talks about the territorial jurisdiction, read with the cause of action arises. This can be, though CPC is not binding in NGTs, we can interpret the cause of action through Section 20 Clause C of CPC also. Here, the cause of action has been inside Toliyanadu, Your Lordship, and no part of cause of action has been a part of Vadakku Pradesh High Court. Your Lordships, in the case of Srimati Rajkumari Thakur versus State of Madhya Pradesh, court held that territorial jurisdiction is foundational and inviolable. With the due permission of the bench, the council directs the bench to flag 7 of the compendium, which has stated Ambika Industries versus Commissioner of Central Excise, which has interpreted between what is dominus litis and what is dominus situs. Litis is where the party is from, and situs is the place where a writ can about whether we can file in another high court. First of all, there is no cause of action that is common in both these places. The question here is applicability of that law. Your Lordship, we have the Supreme Court and Article 141, which states only the Supreme Court judgments are binding, and there is no provision, including Article 226, 227, which we can trace the history back to EIC versus Collector of Customs case.
Can you explain the concept of the persuasive value of such a judgment?
Indeed, Your Lordship, the council does not deny that the high courts do have persuasive value, and it is according to the discretion of another high court judge to either agree or disagree with the same. However, the council would like to cite the case of Surya Devi Rai versus Ram Chandra Rai, which is there in flag 2 of the compendium.
Before that, which of the two pollution control boards you are arguing this on behalf of?
Your Lordship, both the pollution control boards, Vadakku Pradesh High Court and Vadakku Pradesh Pollution Control Board and Tamil Nadu. Indeed, Your Lordship, one is under Section 22 of NGT Act and other is under Article 136 of the Constitution.
What is the SLP for? What is your ground of against the High Court judgment?
Your Lordship, stating that the SPCB should have power to claim compensation is the appeal that
Where is the
demanded
territorial
by the
applicability
respondents.
when you are arguing that?
Your Lordships, the territorial applicability that the council is submitting here is the respondents have relied on Kusub Ignots, which says that a high court can be extraterritorially applicable in central legislations, and under Article 226 Clause 2, that will be the reliance.
Isn't that a separate issue? You're only on the question whether the judgment is applicable only within that state or not.
Indeed, Your Lordship, if Vadakku Pradesh High Court's judgment is applicable in Tamil Nadu or not. That is the issue that the council is humbly arguing. The council like to submit that the Kusum Ignat's case is about constitutional validity, which is very different from the current case, Your Lordships. Your Lordship, the Vadakku Pradesh. Your Lordship, the Vadakku Pradesh High Court has said that there is no power. However, under Section 31A of 33A and Section 5, respectively, of what? Similar provisions, Your Lordship. Your Lordship, the council is not able to hear.
Sorry.
Much of it.
My question is whether the impugned orders made by the two pollution control boards are invoking the same power of law or different powers of law.
Your Lordship, the
Which power was invoked by the Vadakku Pradesh Pollution Control Board? Which power was invoked by the Tamil Nadu Pollution?
Indeed,
Just
Your
point
Lordship.
out.
Indeed, Your Lordship. As per page number para 23, page number 7, the Vadakku Pradesh has relied on Section 33A of the Water Act, Section 31A of the Air Act, Your Lordships. And the other one has, as per the NGT's order, in page number 14, para 14, Your Lordships, page number 5. Indeed, Your Lordships. Indeed, Your Lordships. The council's humble submission is the respondents cannot be relying on Kusum Ignats because it's firstly, it's mere arbitrary dicta. Secondly, the question in the judgment. Indeed, Your Lordships. Indeed, Your Lordships. Indeed, Your Lordships. Much obliged, Your Lordships. The TNPCB processed the reply of the KIA and rejected the plea of KIA and issued a final direction under Section 5 of the Environmental Protection Act, imposing Indeed, Your Lordships. Indeed, Your Lordships. Indeed, not Your Lordship. The council pleads apologies. The council cited this for the NGT, and now in the current dispute, these both. Indeed, Your Lordship. Indeed, Your Lordships. Your Lordship, that is the contention of the council. It is not binding. We cannot connect the Vadakku Pradesh High Court to the Tamil Nadu judgment. It should not be binding is the contention of the council. Indeed, Your Lordship, that is the contention of the council. Indeed, Your Lordship, because the respondents have brought up this claim, the council is answering. Indeed, Your Lordship, the council proceed with the argument. Firstly, Your Lordships, the Vadakku Pradesh High Court in itself has worked on different statutes, as the Lordships have rightly pointed out, and the council humbly submits to the same. However, the Tamil Nadu has come under Environment Protection Act Section 5. The reason is the issue in itself is drafted with relevance to Article 226 Clause 2 and
let's get back to your argument.
Indeed, Your Lordships.
So, if the High Court of one state interprets the central statute,
Indeed, Your Lordships.
why do you say it has no binding force in any other state for so long as that other state's High Court is silent about it? Please argue that.
Indeed, Your Lordship. The council like to submit that on 3 different folds. First thing being, here according to Section 25 of the Environmental Protection Act in itself, it states that for discharge, Your Lordship, the council needs to, Your Lordship, the council like to cite its Water Act. It's not Environmental Protection.
when a High Court of one jurisdiction pass order, and it is about the Central Act, and it may not, it may have jurisdiction only the state. But if the other state High Court has not passed any order, it is not occupied field, then what is the difficulty in following that judgment? That
Your Lordship, the humble answer to that is there's a current Supreme Court judgment called Delhi DPCC, Delhi Pollution Control Committee versus Lodi Properties, which states against this Vadakku Pradesh High Court's ratio, which says that there's a Supreme Court judgment which is superior to all, which says there's indeed power that will be the second.
Question by lordships is not that. The DPCC judgment is specific to Water Act and Air Act. The
Indeed,
question by the honorable bench is a High Court interpreting a central law. As long as there is no contrary view by another High Court, will it bind or will it not bind?
Your Lordship, that is according
Not
to the
with reference
discretion.
to Water Act. Air
Much
Act.
obliged, Your Lordships. That will be in reference to the discretion of the High Court. In Tolyanu's High Court, this case has not been held, Your Lordships.
Not, there is no case pending before another High Court.
Okay. Your
One High
Lordships,
Court
indeed, Your
has
Lordships.
interpreted a central act or a central rule.
Indeed, Your
There
Lordships.
is no view taken by another High Court.
Indeed, Your
In
Lordships.
such a situation, whether in that territorial state, the judgment of another High Court will apply or not apply for the authorities to enforce.
Indeed, Your Lordships. The Council would like to answer that question in two folds. First fold, citing the Kusum Ignatz case, which stated that when it's about constitutionality of a law, considering it void in one High Court and considering it valid in different High Court may cause a conflict, and that was the arbiter dictum. However, attracting that to the facts of the case.
Can you show us Kusum Ignatz and point out what you are?
Indeed, Your Lordships. The Council would like to, Your Lordship, the Council would like to state the case of CIT versus, in the compendium, there's Kusum Ignatz case, Your Lordship, which is in flag number. Your Lordship, the Council pleads the flag number is not.
Go ahead. Please go ahead.
Fine.
Please.
I think what you means when valid the central contrary part or article sometimes and then a central statute coming to the conclusion that it offends part 3.
Indeed, Your Lordship.
Now, be an arbiter of the Supreme Court under Article 140, that is binding.
Indeed, Your Lordships.
Argue why
Your
that
Lordship.
principle should not be applied.
Your Lordship, the principle should not be applied in this case. The first thing being this case does not deal with constitutionality of the act. However, it deals with the interpretation of the laws. Secondly, here the State Pollution Control Board in itself is a party, not only Central Pollution Control Board. Your Lordship, Section 25 of the Water Act states, for establishing a new industry or effluent release, we need the state's consent. This shows how states' supremacy is mandated through the act in itself. The Council would like to state the case of CIT versus Tana Electricity Supply Limited, which stated that if we give a discretion to every High Court to come up with its own interpretation of central law and go by binding that, we will be forming High Court of India, Your Lordships, whereas we only have Supreme Court of India and not High Court of India. Your Lordship, the Council would like to give an analogy to this for the betterment of understanding. In the case, in the Honorable Madras High Court, in the case of
environment is similar throughout the country, you know.
Indeed,
When the
Your
Madras High
Lordship.
Court gives the judgment on environmental law,
Indeed, Your
and
Lordship.
that environment is situated in Delhi also.
Indeed, Your Lordship.
And why do you say that, in fact, environment is more than the constitution? It is life of a person.
Adding to what His Lordship has said, what are the 3 acts that are involved in this?
The Water Act, Air Act, and Environmental Protection Act, Your
All the 3 are
Lordships.
central acts.
Indeed, Your Lordships.
And when all the 3 are central acts and one High Court has given a binding precedent, would it not be binding on the other High Court till such time it's overruled by the Supreme Court or a contrary view is taken by the High Court? That's the long and short of it. That's-
Indeed, Your Lordships. The answer to that is it has been overruled by the Supreme Court in DPCC versus Lodi Property, stating state pollution control boards have power, firstly. Secondly, the Council like to reiterate this with an analogy. The Honorable Madras.
Overruling was only with reference to Water and Air Act. Supreme Court has left open the issue of environment protection.
Indeed, Your
The
Lordships. But
power under Section 33A and 31A and Section 5, are they similar or are they dissimilar?
they are similar, Your Lordships.
Do they have a closure power under Section 5?
There may be minor differences, but the major intention of the legislation
Anyways,
is the same, Your
the
Lord.
Section 5 of the EP Act has been overruled.
Overruled. Indeed, not, Your Lordships.
So then the question remains open.
Indeed, Your Lordships, that is the whole reason why we are here in front of this Honorable Supreme Court. However, the Council reiterating the analogy that the Council wanted to state.
You know, the Honorable Judge asked you
Indeed, your
that unless
lordships.
it is overruled or a contrary view is taken,
Indeed,
will
your
it not be
lordships.
binding? Overruled, the judgment you are referring to, it's only 33A and 31A is
Indeed,
overruled.
your
We leave
lordships.
that 33 and 31. Section 5 is not overruled.
Indeed,
And
your
there is no
lordships.
contrary view taken by any High Court by the Tolliya Nadu.
Indeed, your
So
lordships.
whether the judgment of the Vadakku Pradesh High Court on the power to issue compensation under Section 5, will it still apply to the other state? That's the
Indeed,
question.
your lordships. Your lordship, tracing from the question. First thing is, the section 31 and 33A of the Water Act and Air Act is overruled by the Supreme Court. That in itself says the Vadakku Pradesh High Court only dealt with these two sections. So that judgment has been overruled by the Supreme Court. So an overruled judgment cannot be binding here is the first argument. Second argument is stating that even though it's a central law, there is always space for different high courts to interpret it differently, your lordship. Indeed, your lordships, that is the question here. There's no high court that has been interpreting here. It is to the discretion of the court to either agree or not, but we cannot place the binding applicability value as the humble contention, your lordships. Stating in the case of CIT.
This is not a case of two High Courts conflicting.
Indeed,
One High
your
Court has taken a view.
Indeed, your
The
lordships.
other High Court, there is no case pending. There's no other High Court. There's only one High Court in the whole case.
Indeed, your lordships.
The statutory authorities in the other state are following the judgment of another state's High Court. Are the statutory authorities correct or wrong?
Your lordship, it is according to the discretion. The NGT's discretion to either apply the judgment or
Not
not.
NGT. The action is taken by the
SPCB.
pollution control.
Indeed, your lordships.
So one state's pollution control board, is it bound by a judgment of the High Court by another state when that state's High Court has no litigation pending to that effect?
Indeed, your lordship. The same question was raised before the NGT by the KIA and the Tolliya Nadu Pollution Control Board, your lordship. For that, the council would like to humbly submit an analogy. That is in the case of CIT versus Mariappa Gounder, the Honorable Madras High Court held Mesne profits as capital, whereas other all southern high courts held Mesne profits as revenue. Your lordship, these shows that even if it's a central law, and other high court may have a different meaning, it is not necessary that our state has to follow another high court's judgment, your lordship. That is the humble submission.
Going back, same thing. Question we're all asking. We're talking about. Example, Harappa Gondas, Andhra and Kerala had taken contrary views.
Indeed, your
We are
lordship.
talking about a case where the southern state, that High Court had taken no view at all.
Indeed, your
Both
lordship.
such a not the Vadakku High Court, Vadakku Pradesh High Court. Not that High Court's binding both the territories of India, Article 226(1).
Your lordship, the council's humble submission is, it is not binding, but at the best, may just have an persuasive value, your lordship. If we consider that every different high court judgment is binding in an high court, then as the CIT versus Tana electricity supply case told, we will have High Court of India, not Supreme Court of India, your lordship. The council like to substantiate the same with ON. Your lordships. Much obliged, your lordships. If the bench is satisfied, the council will sum up this issue and move on to the next issue. Much obliged, your lordship. The summing up to the issue, we come
Forget
with
the summing up. Move on to the next.
much obliged, your lordship. The second issue that the council will be dealing with is if SPCB has power to impose compensation or not. Your lordship, the reliance will be placed on legislation first, section 33A of the Water Act, your lordship, which is similar in 31A of the Air Act. The council would like to humbly read if the bench permits. Much obliged, your lordship. There is, according to section 33A of the Water Act and section 31A of the Air Act and section 5 of the EPA, the council agrees that there is no explicit mention of compensation. However, the council would like to cite, according to flag number 8 of the compendium, in DPCC versus Lodi Properties, the Supreme Court had talked about legislative grammar elastic in page number 38 of the compendium, your lordships, which says that grammar of the statute should be elastic in nature and legislative intent should be applied to the same. This can be correlated with the doctrine of implied powers, your lordships. Your lordships, it states that quando lex aliquid alisue concedit concedere vidiutor et ide sign quares ipsa is non-protest.
Council, under 33A, isn't there a specific proviso which says that subject to the provisions of the Act? Is there any provision of the Act which draws support for imposing compensation on the party concerned?
Indeed, your lordships. The council like to state section 9 of the Environmental Protection Act, section 22 of the Air Act, and section 23 of the Environmental Protection Act, one by one, your lordship.
Each act has a standalone effect. I'm sure
Indeed,
you're
your
conscious
lordships.
about that.
Indeed, your
So
lordships.
when the act says subject to the provisions of the act, then you have to draw the power from the act itself,
Indeed,
water
your
act
lordships.
itself.
From all the three different acts.
No, you cannot interrelate the acts. Then it will be saying like subject to the Constitution of India. Then every act can come into play. My question
indeed,
is
your
very
lordships.
specific. Where is the provision? I agree that the discretionary power is given to the board. But that said, it makes it clear that subject to the statutory provisions which have been provided for in the Water Act
Indeed, your
or Air
lordships.
Act as the case may be.
Indeed, your
So
lordships.
where do you get it from 33A or 31 of Air Act, wherein you have the explicit power empowering the CPCB or SPCB as the case may be to apply for to apply the provisions of environmental compensation?
Indeed, your lordships. According to section 9 of the what?
Please do not go back to Environment Protection Act.
Did
We
not,
made that position very clear.
Your lordships, according to section 9 of the Air Act.
No, if you're not aware of it, please move on. No problem.
No, indeed, your
No, you are referring to direction, inclusive direction. Direction including. That word you are insisting.
Indeed, your lordships.
So you, when it says closure of industry, prohibition process, stoppage of electricity and water supply,
Indeed, your lordships.
and any other direction. You have to interpret ism generis. Can you impose a compensation? Can you punish a person?
Indeed, your lordships, the council like to read the provision for section 22A of the Air Act, which states, Air Act, your lordship. Water Act, the council had interpreted, the council will interpret one by one, your lordships. Firstly, the Air Act, according to section 31A, the council would like to read section 22A, power of board to make application to court for restraining person from causing air pollution, 22A, clause 3, clause B. Authorize the board if the direction under clause A is not complied with the person to whom such direction is issued to implement the direction in such manner as may be specified by the court. So the final decision here is given by the court. Reiterating back to the DPCC versus Lodhi properties, the Supreme Court judgment told that section 31A, 33A and EP Environment Protection Act reference will be furtherance made. Firstly, these two statutes will be dealt. Should be read with elastic legislature, your lordships. Your lordships, there is a difference between punitive measures and ex ante measures, which was very well established in the Supreme Court judgment. Here,
What? According to you.
restitutive measure, your lordship. Your lordship, the council humbly submits that here the compensation is restitutive measure, which is and the penalty is different, where there should be conduction of trials and punitive action. Here, since it's a strict restitutory measure, the SPCB can have the power. Your lordship, the central
How have you
government.
quantified the restitution?
Indeed, your lordships.
In the absence of reference to the same, how will you draw the same power to another statute, to another authority? The power to compensate for restitution or the restitution of the damages is a specific statutory power and statutory procedure self-contained in section 15. The parliament is aware of 33A and 31A. There are earlier enactments. Still enacts section 15 of the NGT Act, gives a specific provision, specific power. So anybody who wants a restitution can file under section 15 and get a restitution. Now that being the statutory process, how is the same power parallelly available under the other statute?
Your lordship, the council
Without an
humbly,
express provision.
much obliged, your lordship. The council humbly submits. Here it is not parallelly available. However, it is the NGT that has directed the State Pollution Control Board to get this restitution, your lordship, according to the facts of the case.
Direction and delegation are two different things.
Indeed, your
Has the
lordships.
NGT directed the authority to move forward and take remedial measures, or has the NGT delegated its power under section 15 of the NGT Act to the Pollution Control Board?
Lordship, the council like to read para 14 of the proposition, which states, the Honorable NGT, on receipt of the report, disposed the case by directing. Apologies, your lordships. If the bench is with the council. The Honorable NGT, on receipt of the report, disposed the case by directing the SPCB to initiate appropriate action against the erring units, including fixing and recovering of environmental compensation from them. So there has been a direction that has happened in this place, your lordships. Your lordship, this shows the implied powers that invest with the SPCB, and as per directions answering to the question of lordships,
Is
that
it an implied power or is it just a delegation of the power of the NGT that has been bestowed upon the Pollution Control Board?
your lordship, it is
Be
both.
clear about that answer.
Your lordship, it is both direction of the NGT, and the NGT has directed. The reason being SPCB in itself has implied power, your lordship, relying on the case of
Statutory authority. Can the court bestow statutory power upon a statutory body which otherwise does not have the power?
your lordship, the council humbly submits that the court cannot bestow the power if statutory does not mention
So
at all.
if you leave aside section 14, paragraph 14, and the fact that NGT could have directed them to take action. Any court's direction means to take action as per law. That is how a court order can only be interpreted. That action has to be as per law. Now, as per law, the action taken is imposing compensation. The claim of the other side is there is no power available under the law to take action. Leave aside the fact it was NGT which directed it. That's only an order. But under the principles of law, do they have the power otherwise or not?
Indeed, your lordship, the council like to cite the doctrine of implied powers, polluter pay principle, and principle of subsidiarity to substantiate the same question, your lordship.
These principles, do they apply to a statutory body or do these principles
Your
apply
lord,
to the sustainable development or precautionary principle, polluter pays, or all section 9 of the NGT
indeed, your lordship.
applicable to the NGT and other courts while doing environmental
Indeed,
justice?
your lordships.
This is a statutory body. It's merely an administrative executive statutory body which has to do its duty within the powers of the law.
Indeed,
The
your
question is whether they have the power under the law. They are not a court. The Pollution Control Board is not a court. They are only a statutory authority. They can only do what the law empowers them to do.
Indeed, your lordships, the council like to answer that question in two different factors. Firstly, being an administrative body, can they possess this function? Secondly, if they have this power in the statute. The first contention would be, your lordship, as per AK Kripak and others versus Union of India, as per flag 15 of the compendium, states that Constitution bench of this court held that distinction between quasi-judicial and administrative order has gradually become thin. Now it is totally eclipsed and obliterated. The same was upheld in the case of Nagendranath Bora versus Commissioner of Hills Division, which says that if it is an administrative power, of quasi-judicial power cannot be restrictive in nature. That should be decided through the facts of the case. Here, coming to the second limb of my argument, according to doctrine of implied powers, which says that law gives anything to anyone, it gives also those things without which the thing itself could not exist. Your lordship, it is very well mentioned in the statute that we have provision to regulate. Here, the ex ante measure, as rightly upheld by the Supreme Court in Lodi Properties, the ex ante measure to restore the ecological balance is indeed a statutory power under doctrine of implied powers. And as per the case of ITO versus MK Mohammed Kunhi, it stated that the tax appellate tribunal has implied power to grant stay of proceedings, even though. Did your lordships? Indeed, not your lordships. It's the principle. There are a flurry of cases in which the similar principle has been held, such as the Union of India versus Paris Laminates, Mahesh Kushwa's versus State of MP, and ITO versus MK Mohammed, where they've said that not necessarily the power should explicitly be given. We can understand it through implied powers, your lordships. Your lordships, in the case of Indian Council.
Whether that power has got a statutory backing.
Indeed,
If
not
like,
your lordships.
then how it can be implemented.
Your lordship, this is through the precedents that we have existing in India that the council humbly requests the binding value
I'm
of the
very
precedents.
interested in your citing Tripac.
Indeed, your
Now,
lordship.
you're saying that the difference between quasi-judicial and administrative is being obliterated. Now, how is that applicable in the facts of your case?
Your lordship, the council humbly submits that the learned lordship had raised a question regarding how as an administrative body, without any statutory backing, they can perform levying compensation powers, your lordship.
So, as her ladyship asked you, if you're going to apply Tripac and follow it up with Mohammed Kunhi, then there should be a primary power
Indeed,
to
your
do
lordship.
the act. And then the incidental powers will flow from that.
Indeed, your
That would
lordship.
be your argument. So then, in the absence of what my brother asked you, as to whether the primary power exists or not,
Indeed, your lordship.
is it a delegated power? Is it a directed power? Can there be a direction without authority? All these questions. So you must first argue where the primary power comes from.
Indeed,
And
your
then you can
lordship.
argue that incidentally they can do all the other things.
Much obliged, Your Lordships. According to Section 23 of the Environmental Protection Act, the central government has the authority to delegate such matters. Here, the central government has delegated to the NGT as per the facts of the case. The NGT, according to para 15, has further directed. Your Lordships, it would be
Council,
difficult.
if
Government
they-
has
if
not
they-
delegated powers to NGT. NGT is an entity created by the parliamentary law.
Indeed, Your
There is no
Lordships.
delegation of powers to NGT.
Indeed, Your Lordships. The provision states that it can delegate to any authority, body, or office.
if at all the power is delegated by the entity to the State Pollution Control Authority, then if the State Control Pollution Authority imposes a penalty, will it be open to the NGT to hear the matter again? Would it
Indeed,
not be
Your
a party
Lordships.
in its own cause?
Indeed, Your Lordships, it will be.
Would not the principle of nemo juris non propria causa apply in that case?
Indeed, Your Lordships, the Council's humble submission here is the NGT has directed and upheld the SPCB's methodology, which will be further dealt by my co-counsel. But the issue that we are handling is the compensation that if it can be levied. The NGT has heard and has given, it was the NGT who asked the SPCB to go get the compensation. Your
Exactly,
Lordships.
Council. Just a very, very subtle distinction. I'm sure you'll be able to appreciate it if you pay mind attention to it.
Indeed, Your
See,
Lordship.
what happens is NGT has a power under Section 15 of the NGT Act.
Indeed, Your Lordship.
If it is a case that NGT has delegated the power to the Pollution Control Board, then there is a subrogation. The Pollution Control Board steps into the shoes of the NGT,
Indeed, Your Lordship.
correct? And then it becomes that NGT and the State Pollution Control Board are on one side and the industries are on the other side,
Indeed, Your Lordship.
which means that it will not be open to the NGT to have jurisdiction over that issue at all.
Indeed, Your Lordships. The Council's humble submission is as per para 6 of the proposition. The central government had delegated Section 5 of the EPA, Your Lordships. As per the above orders, through multiple orders of the NGT, the provision was delegated, Your Lordships. The Council's humble submission here is that the SPCB, the learned opponents have in the memorial claimed double jeopardy for the same issue. That is, double jeopardy only applies in criminal cases, Your Lordship, under Article 20, Clause 2. And they've also relied on Article.
Is penalty a criminal offense or not?
Your Lordship,
When is a penalty levied for any civil consequence?
the
Civil
Council's,
consequence, have you heard of the concept called torts?
indeed, Your Lordships, the Council's humble submission is this is not a penalty.
I just want to understand whether you're talking about damages or penalty. If it's damages, it's a civil case. If it's a penalty, then Article 20, subclause 2, jeopardy will apply simply because, and even ex post facto law will apply.
Indeed, Your Lordships.
Because penalty is a criminal offense,
Indeed.
punishment for a criminal offense. The phrase penalty.
Indeed, Your
Well,
Lordships.
so how do you substantiate your argument?
Indeed, Your Lordships. The Council has previously stated penalty or punitive measures, and we have considered compensation to be a restitutory measure under the civil dispute, which we state because it's an ex ante measure that we take for restoring the ecological balance, Your
So the
Lordships.
question is very specific. Is it double jeopardy if a penalty is posed or not?
Your Lordship, double jeopardy can apply when penalty is imposed. Here, the storyline is about compensation imposition, which is a civil dispute, Your Lordship. So, double jeopardy cannot be raised before the Honorable Court of Law. Your Lordship, the second, reiterating back to the arguments of the Council would like to humbly rely upon the principle of subsidiarity, which states that under Section 15, NGT indeed has powers. I think this will be answering the judge's question regarding when NGT in itself has power, will it be the same party? Your Lordship,
Principle of what? I didn't catch that word. Subsidy?
subsidiarity, Your Lordships. By contrast, Section 33A and 31A empowers boards to issue administrative enforcement directions, including recovery of EC. As an interim regulatory measure, the two powers are complementary and not contradictory. This dual system reflects the constitutional principle of subsidiarity, enforcement at lowest level of boards, judicial remedy at specialized tribunals. Your Lordship, here we are just trying that because NGT cannot get down on spot and understand what is the issue, whereas SPCB can better understand in the spot ground level workings, Your Lordships.
I thought there was a technical committee appointed for the purpose.
Indeed, Your Lordships, it was appointed. That was for
Are you saying
training.
that now the technical committee, NGT and the SPCB are on the same side?
Your Lordships, the
Then
council
we are
would be
talking about a
happy.
dictatorship state.
Indeed not, Your Lordship. The council submits only about the compensation claiming, not about who is
Yes,
responsible
please
in
sum
life.
up your second argument and close it. I think we are running out of time.
Lordships, the council like to complete the second argument with the State Pollution Control Board Odisha versus MS Swastik Ispat case, which states that in present case, it is not consequence of punitive or penal action, but in exercise of the powers vested in board in relation to recalling conditions of consent and ensuring their implementation, while also making compensatory provisions for remedying the apprehended wrong to the environment. It is in flag 7 of the compendium, your lordships. They squarely fall within the power of the board to prevent control pollution in connoissance with the scheme of the act as established by the council. The council would like to sum up by stating that the High Court judgment of Vadakku Pradesh is not applicable in Toliyanadu, and SPCB, relying on the judgment of the Supreme Court on August 4, 2025, is indeed having the power. And summing up, the opponent learned councils have raised constitutionally disputes saying we are going against Article 14, Article 21, and Article 19, Clause 1A. There is no arbitrariness here because the methodology is going to be executed to them. There is no Article 19(1), Clause 1A, because there is an exception to the same for public order, and MC Mehta versus Union of India raised absolute liability on the same dispute. And the third thing being Article 21 is right to life and liberty in itself is ecological balance, your lordships. We can't damage ecosystem and say we're claiming right to life for the industries, your lordship. Submitting these arguments, the council please to withdraw. It was in great honor before this bench, your lord.
Greetings to the Honorable Bench. This is Counsel 2 who shall be addressing on issue number 3 and issue number 4. Issue number 3 deals with whether, if the pollution control boards do have the power to impose compensation, whether the methodology that has been devised by the Central Pollution Control Board can be utilized to impose the same. The Council humbly submits that the methodology devised by the CPCB can be used and shall substantiate the same in 3 points. The very first point being, indeed, under recognizing Section 15 of the National Green Tribunal Act, it empowers the NGT to impose any relief, compensation, or restitution on parties who have caused any pollution to the environment. According to the case of Paryavaran Suraksha Samriddhi versus Union of India, which is in flag 5 of the compendium, which was a case that happened in 2017, where the National Green Tribunal, under the power that was given under Section 15, had directed the Central Pollution Control Board to prepare a methodology for calculation of environmental compensation. Now, this was only given to the Central Pollution Control Board to ensure that only the Central Pollution Control Board would come up with a methodology that would uniformly apply throughout the country. The Council would like to also take reference to the case of Velu District Environmental Monitor versus Collector, which is in page 57 of the compendium. If the Council may direct your Lordship's attention to page 57. Where it states that the court can certainly give directions to the central government or its delegate to take all such measures in any given case. This court finds such directions to be warranted. It states that the court, that is the National Green Tribunal, can give such directions to the central government or its delegate to ensure that there is a duty of the state government also to ensure that money is recovered for compensation. Therefore, your lordships, proceeding with both this direction and the fact that such direction can be provided by the court, in 2019, a report was formulated by the Central Pollution Control Board, which was also considered by the National Green Tribunal in the Paryavaran case, which is in page 30 and 32 of the compendium, which the National Green Tribunal had looked into the methodology, page 30 and 32 of the compendium. May the Council. Much obliged.
Under the fact, paragraph 20, it speaks of 50 crores, para 21, 50 crores.
Indeed, your lordship.
Now, was this 50 crores on the basis of the money actually expended by the PCB in restitution, or is it prior to restitution an anticipatory amount you're claiming?
It is an anticipatory measure, and this has been calculated by a formula. Now, this formula was devised by the Central Pollution Control Board in 2019 according to its report, where they considered a formula where the Council would like to read out the formula, where the environmental compensation is a multiplication of the pollution index, that is how much pollution has been caused, the number of days in which pollution has occurred, the rupees, and also the scale of operation of the industries, as well as the location factor. Considering all of this, the report was formed.
In your view, Council, how do you view the word compensation?
Your Lordship, compensation here is whatever damage has been occurred on the environment. In order to make sure that the environment can be restituted and to whatever to undo the damages that have been caused, they have been imposing compensation to ensure that they can restore the environment.
Now, take a look at the table you've referred to. Now, it speaks of the number of days for which the wrong. How is that relevant in finding out the cost of restitution?
Your Lordship, when they're considering the number of days, because when considering how much compensation needs to be devised, there needs to be an ascertainment of what is the extent of harm that has been done by the industries. To ascertain what extent of harm has been done, that is the reason as to why they're considering the number of days in which the
Could
pollution
there not be a case where the cleanup cost of a particular environmental harm flattens, the number of days reaches between 300 days of damage and going to be the same? So why is the number of days relevant at all?
The number of days shows that if one industry, for example, if an industry is doing a pollution of, let's say, of X amount.
I'll put that question in context.
Indeed,
If you apply this formula
indeed,
for something like a Bhopal gas tragedy today, your number of days will be 1. Your formula will give you not even 1/100th of what the damage was. If you apply the formula to Bhopal gas tragedy, please tell me what is the figure you will arrive at. It was in the outskirts. It was a rural area. The pollution index was low for the industry. You will get nothing.
Your Lordship, but the formula does not consider just the number of days. It
You apply the
considers-
formula and tell me what will be the compensation for Bhopal gas.
Your Lordship, at the present moment, the council cannot.
10,000 rupees. We did that calculation. That's the question.
The point is this. Okay. Now, take the number of single point incident, as my learned brother said. I'm just saying that number of days is not a relevant factor. What do you say for that?
Your Lordship, the reason as to why the CPCB has considered the number of days is to see the extent of damage as what has occurred, because the extent of damage is relevant to how much compensation needs to be gathered from these industries, polluting industries.
No, then it's not compensation, isn't it? So that's what we were checking. What your thinking was. If it's the extent of damage caused, then you're actually punishing the person. Whereas if you're seeing the repair cost, that's a different. Then it's compensatory.
Your Lordship,
Which is why I want to understand from you all of the criteria you mentioned in CPCB, as mentioned in the formulae, pertain to the wrongdoer and the extent of wrong done. And we understand that the polluter must pay.
Your Lordship.
But that is punitive. When you speak of compensation, it has to be restitutive.
Indeed, Your Lordship, then the council had stated to the extent of harm. It is to ensure that whatever harm has been committed, that in order to be restituted, that compensation is trying to be derived, which can only be understood if whatever harm has been done can be put into some numerical value. Here,
The question becomes relevant because reparation and compensation are two different components. If you're looking at reparation, then that's a separate story altogether. If you're looking at compensation, then the parties concerned should be put on notice. They should be given an opportunity to question that, and they should be heard first, and specific liability should be fixed on the party before fixing and compensation.
Your
So
Lordship,
which of the two methodologies have you adopted?
Your
Is
Lordship,
there anything on the record to show that all these parties are put on notice? Because you can't make it a reverse class action, saying that, okay, 234 units are there without looking at the proportionate pollution level on their part. You cannot apply a blanket formula.
indeed,
So in this case, you applied a blanket formula which runs against the judgments of the Supreme Court, which say that you cannot have a rigid formula about such thing.
Your Lordship, if the council may direct Your Lordship's attention to para 21 of the proposition, where it says that each of the units were separately given a table as per the CPCB methodology to arrive at the environmental compensation for them. So this was they were given the reports as to how they derived such formulas, and they were also issued show cause notices to ensure that they were also heard to gain their response as well, which the council will further deal with it in the fourth issue relating to. If the council may proceed with this issue, the council would also like to state when it comes to the CPCB's power to devise such methodology, it is the contention was that this was a direction given by the NGT. But even if we look at the CPCB in isolation, the council would like to take reference to section 16 of the Water Act, where it talks about the functions of the Central Pollution Control Board, where under clause F, just a moment, Your Lordships, the council Apologies, Your Lordship. Yes, clause F of section 16, where it says that the Central Pollution Control Board can collect, compile, and publish technical and statistical data and the measures devised for its effective prevention and control, and prepare manuals, codes, or guides relating to treatment and disposal of sewage and trade effluents, and disseminate information connected therewith. Now, in the
Can you give the provision whereby the state pollution control boards are bound by the directives or formulae arrived by the central pollution control?
apologies, Your Lordship.
Under what provision can the state pollution control board apply the law, the formula that has been derived by, formula that has been formulated by the central pollution control board and apply it directly?
Your Lordship, so according to this, where the functions of the board, this has been, they have the right to create a guideline relating to the treatment and disposal of sewage and trade.
My question is, if a guideline is formulated by the central government, is the state government ipso facto bound by that, or they can derive their own methodology according to the existing circumstance?
CPC.
But if the state pollution control boards were to devise their own methodology, then it would be such that each state would be following different methods. Now that would create ununiformity, and therefore.
Are you now questioning the federal system?
Indeed not, Your Lordships. The council is simply.
Then why CPCB then? You abolished CPCB?
Indeed not.
Give it to the SPCB and.
Your Lordship, the council is trying to contend that yes, the State Pollution Control Board has the right to impose compensation. But to devise such methodology, that guide has been given by the Central Pollution Control Board to ensure that there is uniformity within the country, so that there is. Indeed.
The ecosystem of a coastal state is different from the ecosystem of a central state. Ecosystem of a mountain state is different from a forest state. In fact, we are asking the exact opposite. How will you have one formula for the whole country? The impact in a rural area, if the rural area is along the coast, the impact is different. If the rural area is along the mountains and forest, the impact is different. If you understand, so on and so forth. How can you have one formula? See, like my learned senior said, if there is an environmental impact, you should do the groundwork of finding out what the impact was, assess what it is. Instead, what you're doing is mere paperwork. You're finding out the details of the industry which you have when you give consent. You know what is his category, you know what is his machinery. You take that into the formula. You take the number of days into the formula. You are dealing with environmental compensation. You're dealing with environmental restoration as a mere paperwork. You have to go to the site and see what was the damage. This formula only needs a couple of papers to arrive at a compensation. Can that be allowed?
Your Lordship, the council would like to humbly contend that applying this formula cannot be a mere paperwork, because the things that, yes, the number of days can be considered as a, however, it also considers the.
Please tell me which part of the formula requires the ground study.
The very first factor is talking about pollution index.
Pollution index is already there for every industry by a document.
Your Lordship, this requires, so it does take into consideration both.
Can you please, if you have research, can you please explain the concept of pollution index? How is it arrived at for a particular industry? If I want to start an industry, how will I know what is my pollution index?
Your Lordship, in this, it specifically relates to how, if in an area, it also talks about the location factor as well.
That's a difference. There are 4 components: pollution index, location, rupee factor, and the number of days.
Indeed, Your Lordship.
Can you please, if you have research, please tell us each of that and tell me which of it requires a ground study. I'm saying if there is a major accident or a minor accident or an impact, I'm alleging against you that all you do is paperwork. You look at the company's papers, you look at the formula, you're sitting at a desk and arriving at an environmental compensation without even going to the site. Can this be allowed by a court of law?
Indeed not, Your Lordship. And even in the present case, it was not that the methodology was just applied without any grounds on work. There was a separate joint expert committee that was formulated by that was constituted by the National Green Tribunal, who had done the hands-on work, who had understood what extent of damage had occurred, and thereafter they had applied the methodology in order to derive at the conclusion.
If the committee has gone and found out what was the damage, they could have straight away said what is the damage. Why do you have to refer to a formula after that?
Your Lordship, to ascertain the particular amount they've devised.
So they have seen what the damage is. They will know if X amount of sand is spoiled or X amount of well water is spoiled, whatever is the damage, or air pollution, this is the value. They already know it. They already know the cost of restitution. Why is there a separate application of a formula? And you never applied the formula until the NGT asked what is the compensation taken. Now, forget the facts. So if a committee has gone, seen the site, seen what the damage is, if they're experts, they will also tell what is the cost required to remediate it. Why apply the formula?
Your lordship, in each and every case, yes, not every case, even in every case, if they were to consider, your lordship, in this case, there was a joint expert committee that was, but they were not able to arrive at a
My learned friend is asking, no doubt the committee has arrived at a figure and it's assessed the extent of damage. The only question is whether such cost has to be taken unit specific, or you can have a blanket formula wherein you just apply the pollution index component alone and conveniently do it, because that comes across as desk work.
Indeed, not your lordship. The another factor that is also there in the formula is the location factor. Now, as your lordship had stated, there could be such that this pollution is occurring in a hill station or a coastal area. It differs. So it does take into consideration the location factor.
My exact question is that in location factor,
Indeed.
do you differentiate between a hill, mountain, forest, and coast?
If the
Please explain the location factor. That's very crucial. Where the impact takes place is very crucial.
Indeed, your
So
lordship.
please tell us in the formula whether it differentiates between different types of ecosystems.
Indeed, your lordship, the very wording of the formula itself is pretty wide. They're not trying to say that this particular location would have to have
No.
this.
Your location factor is urban, rural. That's all. Does it have any further classification? I'm asking for my own understanding.
Your lordship, so in the 2019 report, this has been given, but there was also a report that was recently given in 2022. However, the reason why the council had not stated it is because that is still being considered by, that still has to be considered by the court. However, the 2022 report gives for further, even more clear instructions as to how the methodology needs to be applied, your lordships. So the council would like to take reliance on the same. If your lordships are satisfied, the council would like to proceed with the next. Much obliged, your lordships. Issue number 4 has within it 2 questions. The first question being, if there is absence of proof of pollution that has been committed, whether liability can be imposed. Your lordships, firstly, the council would like to contend that there is proof of a pollution that has been stated in the facts of the proposition. As per paragraph 12 of the proposition, it does state that, if the council may. It has been that relates report by the Joint Technical Committee, where in para 13 they stated that the committee also listed about a total of 234 units where they had also contributed to the river pollution.
Please read para 12 and 13 again. Para 12, the committee identified that there is evidence of both sewage and industrial effluents mixing in the river.
Indeed,
based on the water analysis. So the river is polluted.
Indeed, your lordship.
No doubt.
Indeed.
The committee identified the district administration as responsible majorly for sewage pollution. So the industries are not alleged. It's only the district administration.
Indeed, your lordship.
For sewage, one aspect. Some households were not connected to sewage pipelines and there was not adequate. The committee listed about 234 units of small, medium and large scale industries situated along the river to have contributed to the industrial pollution, since the inspections revealed that the units did not have valid consent orders or renewal, and they were in operation of the plant without a properly functioning treatment system or pollution control measure. It does give a direct proof that there was any effluent discharge by the industry. Merely because they did not have a consent or a renewal or some systems were not properly functioning, there is an assumption that these industries are polluted. So there is no direct proof.
Your lordship, so 2 points that the council would want to state. According to para 17 of the proposition, where they the reply to the show cause notices by the KIA, in page number 6, they've mentioned that they're contradicting themselves, your lordships, because...
No. Is there direct proof by the committee, yes or no?
Your lordship, it can be understood that there is proof of pollution. The council would like to state that firstly, first of all, they themselves are contradicting. First, they're saying
Forget
that...
them.
Okay.
They are yet to argue. Forget them.
Your
What is your case?
Your lordship, they've
Can you fix liability without a direct proof of pollution?
Your lordship, indeed, the council will substantiate on the same, but the council first wanted to say that there is proof in the present case that can be understood, but will further also establish that even absence of proof...
You're talking about circumstantial evidence. No, my question is, if an industry does not have a renewal of consent, am I to assume that he is damaging the environment? If he says that I might not have a renewal of consent and it is a procedural error that I will rectify, but that does not automatically mean I am damaging the environment. This is the issue.
Indeed, Your Lordship, the council humbly agrees with you on the same. However, the council wanted to refer to the para where they're saying that it had many of their member plants were undergoing repairs and upgradations during inspections. They were stating that they had themselves stated that their machinery to treat the effluents were under repair and it was not functioning properly. They had stated this in their reply.
So they would not have discharged, they would have stored the effluent. Did you check that?
Your Lordship,
An
so-
effluent treatment system not working properly does not mean I am bypassing it and putting it outside. I can store it till the system is restored to treat it.
Your Lordship, so there are 2 points here. As has been clearly stated under the report, it is clear the river has been polluted by effluents. This,
And one more aspect to bear in mind is the portion of the river that we are talking about is the downstream. Why are you targeting the industries in one district? This is the downstream. You should then go through the entire length of the river to find out who are all contributing. So anywhere any pollution caused flows down south, and the closest, the last point is where the pollution is at maximum. You find the nearest person situated there and say he does not have a renewal of consent and fix the whole liability on him.
Your Lordship, the council is not stating that because of their consent order is not how we are arriving at the conclusion that they have polluted. The conclusion is arrived because clearly the river does have trade effluents. And according to the case of Samriti Mehta
And also
versus
to
Union
add to that, if you say that you had proof they were polluting, you issued a show cause notice for closure. You did not pursue that. If they are polluting, why did you not close them? You issued a show cause notice for closure and you did not pursue it. You left it. You gave them time to remediate. You gave them time to rectify these pollution control measures. You filed a compliance report before the NGT saying that they have complied with everything. The NGT asked why you did not impose compensation. You invoked the formula and impose a compensation. Now this has become a pattern. You went for inspection. If they were polluting, you've given a show cause notice. If
Indeed,
they
Your
were
Lordship.
polluting, you should have closed. The fact that you did not close and assuming that you did your duty properly, we should only assume they were not polluting. Therefore, you did not close.
Your Lordship, but even after that, the consent orders were only extended. And even after that, still the NGT, considering all the reports that were submitted.
Go to issue number 4.
Indeed, Your Lordship, the council is contending on issue number 4 relating to the, indeed, Your Lordship, relating to the absence of proof.
Is in your favor, little bit.
Indeed, Your Lordship.
Do that.
Indeed, Your Lordship. So relating to, even if there is, considering that there is absence of proof, whether the council would like to contend that there is still liability that can be imposed, the council would like to take reliance on the case of MC Mehta versus Union of India, where the principle of absolute liability was applied. Where if the industry is dealing with such effluents, it is their responsibility to make sure that they treat it properly and not release it into the environment.
Council, there is only one little hitch in the entire process. Admittedly, these units did not consent. They were not under your direct jurisdiction in terms of having secured a clearance from the Pollution Control Board. Right?
Indeed, Your Lordship.
Which means you also did not know the volume of each of the unit. The exact standard and volume on which capacity with which the units are operating. Will it be all right for you to apply a general formula for all the 234 units without actually knowing the capacity of such unit? Because there's nothing in the statement of facts which shows that you had assessed the individual capacity of each of the units before applying the formula and thereafter ensuring that the compensation is being paid for.
Your Lordship, so firstly, as per the facts of the case, it does state that the 234 units are of different sizes. There are small, medium, and large scale industries. As per para 21 of the proposition, it has been stated that the methodology has been applied separately. It states that the units were separately given a table as per the CPCB methodology. Therefore, it was formulated with each scale in mind, scale of operation in mind, Your Lord. And continuing on with the
17, there are 4.5 points given.
indeed,
They
Your
are
Lordship.
under repair,
Indeed, Your Lordship.
and then they're willing to do the necessary repair work and other things. And some people said they will upgrade the machineries. Then they said due to financial crisis, they have not in operation. And they have COVID, they have just closed and they are trying to work out. And they have yet to start the production. In those cases, how do you assess? So it is difficult for you to assess each and every unit on the same category. So that the problem is, how did you use the methodology on one set of units? Units vary from industry size to production level.
Indeed.
So each and everything, which methodology you use for bringing out the, fixing the compensation. According to it's a compensation.
Indeed, Your Lordship. And even if we look at the formula itself, it does consider the scale of operation. So that it does take into consideration if it is a small scale industry, medium scale industry, or large scale industry. So the methodology does account for it.
Should you not ascertain the actual damages caused to the environment before deciding the compensation? How can you categorize people like this? 3 categories of people, and by assumption and presumptions, how can you do that? See, actually, compensation means actual damages cost is to be recouped
Indeed, Your
by
Lordship.
way of compensation.
Indeed,
That requires assessment in respect of individual units.
Indeed, Your Lordship. And individual units have been considered, and they have also been given the report as to how they were derived at the conclusion for whatever compensation that they're imposing on them. Each units were given the report as to how it was derived, Your Lordship. And
I think Ladyship's question and my lord's question are, you are now arguing the appeal before the Supreme Court.
indeed, Your Lordship.
Therefore, you can't really see inferior authorities as a precedent before us. Is a one size fits all, is that approach valid or not? That's the question we are repeatedly asking you.
The
You
council.
can't simply tell us that CPCB formula is this. We are questioning the legitimacy of that very formula. We are saying one size fits all. How are you applying it? How is it valid? That's our question to you.
Your Lordship, so the council is contending that this is not a very restrictive formula. It does require hands-on work to be done as to determine what is the extent of damage that has occurred, and and it does consider, it has a very wide interpretation of each term under the formula. And as the council had stated, there was also a 2022 report that further substantiated this formula, and it explained in extensive as to what is the methodology that should be used in order to derive to such compensation. The council would like to just sum up the arguments. Much obliged, Your Lordships. So the council would like to state that as per the 4th issue, that even with absence of proof, there can still be imposition of liability on the industries due to the principle of absolute liability, as can be seen in the MC Mehta versus Union of India case, and also in the case of Samrita Mehta versus Union of India. And further, the second question relating to whether the High Court judgment and the NGT judgment are liable to be set aside, the council humbly submits that it is indeed liable to be set aside, as clearly even in the Supreme Court case, Honorable Supreme Court case of Delhi Pollution Control Committee versus Lodi Property, and also in the Allahabad High Court case, in the case of Ramesh Dyeing versus and washing versus State of UP, both had held that the State Pollution Control Board do have the power to impose such compensation, and therefore these judgments are liable to be set aside. If Your Lordships are satisfied with the arguments, the council would like to proceed with the prayer. Much obliged, Your Lord. Much obliged, Your Lordships. It was an honor presenting before this bench.
May it please the court, the council seeks permission to begin. Much obliged. The convenience of the bench, the council seeks permission to collectively address the bench as Your Lordships. Much obliged, Your Lordships. Your Lordships, this is the council appearing on behalf of the respondents in the instant case of TNPCB versus Keeladi Industrial Units Association, as well as in the case of Vadakku Pradesh Pollution Control Board versus MS Bhakti Corporations. This is council number 1, who will be arguing on issues 1 and 2 respectively, and my co-counsel will be arguing for issue 3 and 4 respectively. If Your Lordships are well versed with the facts of the case, the council seeks permission to move on with issues in hand. Much obliged, Your Lordships. Your Lordships, the first issue in hand deals with whether the judgment of Vadakku Pradesh High Court can have an pan-nation applicability or an extraterritorial applicability in respect of other high courts, as well as it talks about, as well as the issue is pertaining to whether a judgment passed by one high court on any central environmental authority, that can be a statute or an office memorandum or a circular, can be held to have a pan-nation applicability. The council will be dealing with the submissions for this issue contentions, and the answer for the same is affirmative with respect to this question of law. The first contention of the council is that the constitutional ambit of Article 226 Clause 2, since it is involved in the question of law in itself, the council is talking about Article 226 Clause 2. Your Lordships, if the council may read the issue in hand, it says whether the judgment of Vadakku Pradesh High Court is applicable beyond its jurisdictional territory,
as per Article 226 Clause 2 of the Constitution. Since the question of law is based on Article 226 Clause 2, the Council will be talking about why 226 Clause 2 is applicable here and whether the judgment is also applicable. So when we look at Article 226 Clause 2, the constitutional mandate for introducing this particular provision is that it was introduced to the amendment. It was not initially a part of the Constitution. Only through the 15th Amendment it was introduced and later replaced in the 42nd Amendment. The intent of the legislator in this manner is clear, that to widen the scope of jurisdiction of an High Court, which is to give, when there is a cause of action, either wholly or partly arising outside the territory of the jurisdiction, if there is a cause of action that ties the High Court to the particular plaint or the particular case, or then it gives the power to issue writs for the High Court. So this is what Article 226 Clause 2 is all about, your lordships. And when we talk about Article 226 Clause 2, it is important to note the cause of action doctrine, which was also utilized in the judgment of Kusum-Ignots. And Kusum-Ignots has been also utilized in framing this particular question of law. Therefore, the council will be also dealing with why Kusum-Ignots is pertinent with respect to this issue in hand, your lordships. Your lordships, the council believes that when one High Court interprets a particular central legislative authority, be it environmental or not, it is necessary for other high courts to uphold the same if there is not a contradictory view that is being taken by other high courts, or if there is not a contradictory judgment that was passed by the Supreme Court with regards to the matter. And this was also reaffirmed in the judgment of the Kusum-Ignots by this honorable court. The lordships, it is because of the principle of judicial uniformity that such a jurisprudence has been formulated in the nation, your lordships, through Kusum-Ignots judgment and through reaffirmation of Kusum-Ignots judgment in various high court
Counsel, I
judgments.
have a question for you.
Yes, your lordships.
In this case, VP-PCB had filed an appeal against the VP High Court ruling.
Indeed, yes, your
Now,
lordships.
Was, I don't know from the facts if that appeal was filed prior to the decision of the NGT in your case. But assume for a minute that the appeal had been filed in the Supreme Court before the NGT ruled. Would that make a difference in the application of Kusum-Ignots, where the BP High Court judgment has not reached finality, it is pending appeal?
Indeed, yes, your lordships. If in case, assuming that whatever the lordships has placed before the council, that contention is that is the contention with respect to the factual matrix. That is, if the judgment was the NGT Southern Zonal judgment was derived based on a judgment which was not final because it is pending for appeal, then it is not correct in law. However, the facts of the case is silent about the timeline of these particular events, your lordships. For the convenience of the bench, the council will be reading paragraph number 26, which says that the Vadaka Pradesh High Court, the Vadaka Pradesh Pollution Control Board has filed an appeal against the said judgment of the High Court before the Supreme Court of Navalandiyam in civil appeal number 133 of 2025. There is no explicit mention of which month or which year this appeal has been filed. And consequently, the 27th para, that is the very next para, states that Kia filed a detailed reply to the TNPCB by contending that as per the judgment of the Vadaka Pradesh High Court, the TNPCB has no power to levy environmental compensation. Your lordship, since the facts is silent about the timeline of the judgment, the council would like to take the view that before the judgment was appealed or before the finality of the judgment was questioned before this honorable bench, that particular judgment, because it has persuasive value, it was applied by the with the NGT.
Counsel, in Kusum-Ignots, was it a case where a ratio was given, or was it just an obiter?
Obiter dicta, your lordship. That answer is very clear because Kusum-Ignots was dealing with the constitutional validity of Sarfasi Acts. However, when we consider obiter dicta, your lordship, there is a settled notion in law because it is a Supreme Court judgment. Article 141, which mandates that.
In the present case, what constitutional validity of which act was settled?
Your lordships, in
the power under the statute is a matter of interpretation.
Indeed, yes, your lordship.
And each high court has the right to interpret it in a manner that it deems fit.
Indeed, yes, your lordship.
Kusum-Ignots related to a central legislation whose validity was under challenge under Section 12. Judicial review was there. Can you compare Kusum-Ignots to the present case where one high court has merely interpreted the power of a pollution control board, whereas no other court has taken a stand. So is it not open to another court or another authority to take a contrary view as against a judgment passed by another high court of a different state?
Indeed, Your Lordship, the council will be answering that question in a twofold manner. Whether, first of all, whether obiter dicta can be applied or said to have a persuasive value. To state that, the council will be citing the judgment of Oriental Insurance Co. Limited versus Meena Varial, where it was stated that when there is a grey area of law as such, which has not been completely decided in a ratio decidendi by the Supreme Court, then the obiter dicta that is passed by the Supreme Court, which is relevant, can be undertaken. So this is the position of the obiter dicta with regards to why Kusumic notes obiter dicta is being applicable. Now coming to the question of your lordship, that is with regards to, if your lordships, apologies your lordships, can you please reinstate the question? Apologies your lordship.
No, I'm only saying whether interpretation of the applicability of a particular section or a particular power be equated to a case where the constitutionality of an act itself was looked into. Am I clear, or should I be? No.
Apologies for the
I'm not. I'm seriously asking you if I'm clear. Sometimes my question may be a little convoluted for you to understand.
No, your lordship. The council is clear with the question. Answer to that is not with entirely to regards to the Kusumic notes judgment, but consequently to the Kusumic notes judgment, the principle that the Kusumic notes judgment, that is the obiter dicta, that was evolved around the Kusumic notes judgment, which is that it is not only limited to the constitutional validity of an act when it is challenged before the Supreme Court, but it also extends to any declaration made by the court with regards to a particular provision's validity or its interpretation. That is the principle around the Kusumic notes judgment and not the judgment in itself, your lordships. And this has been upheld by various high courts. For the Kerala High Court has upheld this particular principle, which is derived through the Kusumic notes judgment. So it is not directly in the judgment in itself, but it's the principle that was derived from the particular judgment, your lordships. Therefore,
one question: if on 26 clause 1 says that any order or direction or writ issued by one high court shall be applicable throughout the territory. 226 clause 2 says that even if part of the cause of action arises within the high court can issue the order. Now I am reading it to say that the high court exercises direction within a territory and it can exercise the jurisdiction even if a part of the cause of action arises. No difficulty. How do you say under 226(1) or 2 that the direction will go beyond the territory? 226(2) doesn't say the direction goes beyond the territory. It says the jurisdiction can be invoked even if a part of the cause of action arises. But the direction goes beyond the territory is not explicit in 226(2).
Indeed, yes, your lordship. The council is well aware of the fact that Article 226 Clause 2 deals with merely extraterritorial jurisdiction of an high court and not with regards to the extraterritorial application.
Not extraterritorial. 226(2) says 226(1)'s jurisdiction can be invoked even if only a part of the cause of action arises. That's what 226(2) is. Now, they can invoke jurisdiction, pass an order, it shall be binding. But this will apply beyond the territory is not there in 226(1) or 2. Your answer.
Much obliged, your lordships. And that is why the question of law in itself ties Article 226 Clause 2 with the Kusumic notes judgment, which widely interpreted Article 226 Clause 2 to talk about the extraterritorial jurisdiction of an high court. However, the issue of law before the Supreme Court talks about the extraterritorial application of a judgment, your lordships. When we talk about application, we will be dealing, the council will like to deal with it in twofold manner, that is enforcement of a judgment and applicability, that is the persuasiveness of a judgment. Here, it is clear that the constitutional mandate only expressly confers the binding nature of a judgment to the Supreme Court under Article 141. It is undisputed. However, when we consider the persuasiveness of a judgment, that applies in this particular case because the judgment that was given by the Vadaka Pradesh High Court with regards to environmental compensation, your lordships, the Vellore case of the Indian Council for Enviro Legal Action merely states that compensation is a part of polluter pays principle and does not quantify the method in which this particular environmental compensation can be levied. So while the jurisprudence that has been given by the Supreme Court merely validates that environmental compensation is a part of polluter pays principle, the gray area of law is with regards to its application when regulatory bodies are concerned. And that is why the judgment of Vadaka Pradesh High Court is relevant in this matter, because the Supreme Court is yet to devise on that particular matter, and that is why the appeal has been also filed with regards to that matter. So this bench will decide whether the environmental compensation can be quantified by a regulatory authority. That question of law is still unanswered by the Supreme Court. If we the friendly council cited the judgment of DPCC with regards to this particular quantification or environmental compensation, Your Lordships. However, it must be duly noted that the DPCC judgment, which is a very recent judgment, it was passed on August 4, 2025. It was given by a three-judge bench. It was not. Therefore, it is not binding on this particular bench, and it is merely persuasive, considering that this is a constitutional bench. And furthermore, Your Lordships, even if we consider the persuasiveness of the particular case before this honorable bench, the opponents have clearly misinterpreted the judgments, because the order, that is the final paragraphs of the judgment, if the council may read, 39. For the reasons stated above, in clause B, the Supreme Court has adjudicated that we direct that the pollution control boards can impose and collect as restitutionary and compensatory damages fixed sum of monies or requires furnishing bank guarantees as an ex ante measure towards potential environmental damage in exercise of its powers under 33A and 31A of Water and Act. The clause C reads that it is further directed that the power to impose or collect restitutionary or compensatory damage or the requirement to furnish bank guarantees as an ex ante measures under these sections shall be enforced only after detailing the principle and procedure incorporating basic principles of natural justice in the subordinate legislation. There is no, the Parliament has not yet enacted a separate subordinate legislation which quantifies the environmental compensation. Therefore, this judgment merely states as while such powers can be given to the regulators, that can only happen after statutory sanction, that is through a subordinate legislation. Therefore, this judgment, even if we consider the persuasive value, it is irrelevant, because it is clear that the Water Act and Air Act merely gives powers, that is the power to issue directions which are not pecuniary in nature. It does not deal with any monetary damages. It only directs with directions, that is binding on the parties that is given. And the explanation, that is the proviso of the particular 33A and 31A, only deals with.
Counsel, what is your answer to their argument on doctrine of implied power?
Your Lordships, to answer the same, if your Lordships are satisfied with issue 1, the council will deal with issue 2 and will answer that question. Your Lordships, when we talk about doctrine of implied powers, in this particular case, it should not be considered, because there is a doctrine which is very to this particular position. That is the, if the council may refer, the maxim of expressio unius est expressio altris. That is, when a particular provision express mention of one thing impliedly excludes the expression of another. Your Lordships, we must look at the legislative history of Act, NGT Act and Environmental Protection Act. Water Act was enacted in 1970. Air Act enacted in 1974. Environmental Protection Act 20. And in 2010, because the Parliament intended that there has to be a special adjudicatory body with regards to this particular issue, it enacted in 2010 this particular act, Your Lordships. Now, coming to the provision of 31A and 33A in itself, Your Lordships, this was initially not a part of the framework of Water Act or Air Act. Only through the 1988 amendment, it was inculcated into this particular act to give directions. And it is only merely directions, and it does not talk about any pecuniary directions as such, Your Lordships. We know that the Water Act has been amended 4 times since 1988, and Air Act has been amended thrice. That is with regards to Jan Viswas, which is in 2023. It's very recent, Your Lordships. And furthermore, Your Lordships,
So it says any direction which includes closure, prohibition of process, stoppage of electricity, water supply.
yes, Your Lordships.
It is not exhaustive, it is inclusive. The inclusive does it not include imposing compensation on you?
Particularly when such a power has been delegated by the NGT to the authority. I'm adding to His Lordship's question.
Indeed, Your Lordship, to answer with regards to the Lordship's question, that when an explanation, it add on provision and not takes away from it, the council would like to refer to a particular case law. The council takes 1 minute.
Not apply in this case. Further, I am telling, expressive unius, est exclusive ulteriors will not apply. Expression of one fact will exclude the other facts, will not apply in this case because any other direction is there.
Indeed, yes, Your Lordships, but when we talk,
Some generation.
indeed, yes, Your Lordships, the council will be also deep.
If you look at section 33A, with the object of the Water Act. If you read the preamble of the Water Act, it says for maintaining and restoring water. So the object is to restore. If that is the object in the preamble of the Act, can we not look at 33A and say it includes?
Your Lordships, the council will be answering that question by using the doctrine of strict interpretation. But before that, the council would like to.
No, it's an environmental act. And when it's a beneficial act which is meant to, if the strict interpretation will not apply. The Honorable Supreme Court has already held time and again.
At any rate, strict interpretation won't be there to support pollution. It will be strict the other way. Therefore,
The intent of the act. The intent of
Yes,
the
Your
act
Lordship.
is very
Lordships, the council will be explaining with regards to this question, but the council would like to clarify the position on the first question that was posed by the Lordship with regards to the explanation part, Your Lordships. Your Lordships, in every legislation, the proviso part or the explanation part is very crucial. As your Lordships rightly pointed out, it adds on to the legislation. However, in the case of S. Sundaram Pillai versus B.R. Pattabhiram, it was held by this honorable court that the courts have consistently held that an explanation must be read harmoniously with the particular provision and must elucidate the main section in such a way that it should not either narrow down or widen the scope of the particular act. So this was what was held with regards to an explanation part of the particular provision, Your Lordships. In this case, directions, that is even the provision part, it merely talks about directions.
What about the maxim that individual inconvenience will have to give way for the larger good?
Sorry, Your Lordship.
Individual inconvenience will have to give way for larger good. That is also a settled maxim of the Supreme Court.
Sorry, Your Lordship.
Individual inconvenience
Entire community at large, not that a single person can be.
Your
And
Lordship.
also a straitjacket formula not be imposed on a particular person.
Indeed, yes, Your Lordship. That is the very contention, Your Lordships. A blanketed formula cannot be used to devise environmental compensation. Your Lordships, when we are talking about 33A and 31A, it merely talks about directions. There is, if the council was, what was the council trying to say is that through so many amendments, if the intention of the legislature, the parliament is to include a direction with regards to a pecuniary or a monetary direction, it would have very well added so, because Your Lordship,
you know what, in
the
that, if
2020
that's your argument, Sundaram Pillai goes against you. In Sundaram Pillai, there's the explanation to 10(2)(1) of the Rent Control Act. All right. And the question was, what constitutes willful default? Now, the main section did not provide the clarity. The explanation said how many months, and the Supreme Court construed that as that beyond the 2-month period, that is when the willful nature can, if at all, be construed. Therefore, in that case, the explanation was the starting point for the exercise of power of scrutiny of whether something is willful default or not. Here too, as His Lordship told you, the explanation is only a starting point of the source of power to interpret what a direction means. Therefore, if you are going to say Sundaram Pillai is going to go against you.
In Your Lordship, to answer the same, if the intention of the legislature was to give the power to control boards to direct a monetary recovery, the Schedule 7 of the Water Act is in monetary nature. It deals with penalties. So if penalties can be levied by state pollution control boards, then rightly so a provision for remedial charges would also be amended. Because the NGT Bill 2022, which is not yet enacted, already Section 15 gives the adjudicatory power to the NGT with regards to relief and compensation. And in this bill, the Section 2 is rightly amended, and Section 3 is also rightly amended, where if a person under Section 15, if he is being granted a relief or compensation, and if he is unsatisfied with such an order and he wishes to appeal it to the Supreme Court, 50% must be deposited with the NGT before.
Exactly the issue, Counsel. If you take that argument under Section 15, if I am personally affected by an environmental damage by an industry, I go to the NGT, pay a court fee of 10% of the damage that I'm claiming, and then the NGT has to adjudicate. In a case, is that to say that if the pollution, you're equating the pollution control board to that situation? You are a number of industries situated along a river polluting. Should the pollution control boards go to the NGT, tell them this is what we think is a damage, pay 10% of the revenue's money as court deposit, conduct a case, and then get the recovery from you, do they not have a power as statutory authorities to straight away punish you for compensation?
Your lordships,
So you are saying that every pollution control board will have to pay a court fee and conduct a case if they want to impose a compensation against.
your lordships, the position with regards to this is that the guideline for show cause notices, when we deal with the show cause notices that is issued by the boards, if there is a gross violation, there is a power for them to directly close without giving an opportunity to be heard. Only in cases of minor compliance issues, they will be giving. This has been also notified in the Ministry of Environment.
You don't get consent for running a unit. You go on pollute the entire area. Then what is the what is to be done? Tell.
Your lordships, indeed, yes, your lordships.
Is it not satisfactory for the pollution control board to take an action against you on the
Your lordships,
the public interest? That is a strict liability, you know, absolute liability.
The council is not disputing whether the actions can be taken by the pollution control boards on erring industries. The position is that such directions cannot be monetary in nature, such as environmental compensations.
33A was amended in 1988. You are answering that question in 2025. In today's situation, where there are a number of industries everywhere, if this court cannot interpret it in a fashion to give the power to the boards to take action to punish you and recover money from you and restore the environment, who is to do that?
That is the very contention, your lordship.
You are saying that the pollution control...
The legislature to give the same, it would have amended so or included, at least included the proviso. But that power under 2010 enacted NGT Act, that has been granted to the adjudicating body.
That is for a single person. If you read section 15's beginning, any person affected by the pollution can file an application, any person, legal person or any other person. This is the state authorities. This is not an individual case. The state authorities, do they not have the, should we interpret it to say, state authorities don't have the power to take an action to recover money for restitution?
Your lordships, if there is such a gross amount of violation, then why not closure, which is a direct power that is given under the provision?
Of course, closure. Closure does not mean that you don't have to pay for the damage you have already made.
Your lordships, however, environmental compensation can only be forward measures, that is ex ante measures as given in the DPCC judgment. Here there is a retrospective application of the environmental compensation, your lordships. If we look at, the council would like to refer to the facts in paragraph number.
No, council, my question is this. If the pollution control boards do not have the power, assuming we agree with you, then who is to take action?
The NGT with regards to...
So you are saying in every case of pollution, somebody has to go to NGT, file an application, conduct a case.
Your lordships, but that is what has been sanctioned by law, your lordships. Just because it might cause inconvenience to certain parties, we cannot overlook the legal sanctions.
Is there any prohibition under the statute prohibiting the authorities from recovering money for restitution?
Your lordships, here the doctrine of occupied field would apply because that particular power to recover relief or compensation has been given statutorily sanctioned to the NGT and not to the pollution control board.
NGT is a court of law.
That is exactly the contention, your lordships. Environmental compensation like 50 crores, 100 crores cannot be simply laid down by a regulatory body. It needs judicial oversight. And that is the very reason why Section 15 has been undertaken in the NGT Act in 2010, your lordships. Indeed, yes, your
According
lordship.
to you, the NGT has got the power.
Yes, your lordships. The NGT has power under Section 15, as well as the NGT under Section 19 has the power to lay down its own procedure of law, that as per its own convenience, because it is not...
So according to the NGT, the amount prescribed, whether it according to is a compensation or it is a penalty, it has been directed, it was directing the pollution control board to recover it from you and pay it, monitor.
Indeed, yes, your lordships.
Then
However,
you say now they have no power. Then now, according to you, the NGT has directed them to do so. You cannot say hot and then it is cold.
indeed, yes, your lordship. The council has two discrepancies with regards to how the TNPCB has acted in this particular manner. Your lordships, the power was, yes, indeed granted by the NGT in this case. The show cause notices, which was initially given, that is dated 18/6/2021, for the district administration for the sewage pollution, it directly levied directly gave a show cause notice saying that you have violated so and so, you are bound to pay 25 crore. However, your lordships, to us it only mandated, it stated that why have you not undertaken so and so measures? If not, we will close you. And there was no express mention of we will also be giving you an environmental compensation of so and so money. If there is an express power of the boards under the provisions, that is 33A and 31A, even though this case was filed in the NGT and the Pollution Control Board is working under the direction of the NGT, such powers are implied as per the arguments of the appellants. If such powers are implied, why not give the show cause notices initially stating that you have to comply and you will be paying for environmental compensation for whatever pollution you have caused so far? That was not the case. Initially, they only told us you have to comply or else we will close you down. And once we have fully complied, they have taken that our compliance report and submitted to NGT. And only after the NGT asking why have you not levied an environmental compensation on these particular erring industries, they have issued a fresh show cause notices on 1/1/2025. There is almost 4-year gaps. There is a lapse. If so, the pollution control boards have power. They have not utilized that power. Then again, this is bad in law with regards to their power because they have not exercised power.
So according to you, they expanded the show cause notice and they've also introduced a penal provision which is not applicable in law.
Sorry, Your Lordship.
They have expanded the show cause notice and they've introduced a new provision in terms of a penal nature which is not applicable in law, is their argument in substance.
Yeah, yes, Your Lordships, because here the doctrine of legitimate expectation will be invoked, Your Lordships, because doctrine of legitimate expectation says that in this particular matter, because it is of an economic nature, Your Lordships, we are
What is the expectation you had?
Your Lordships, compliance is mandatory. That is that is not disputed by the council.
You argued the doctrine of legitimate expectation. I want to understand what is the expectation you had.
That because the initial show cause notices merely talked about complying or closure, we thought that if we have all the compliance measures in place, we will be given the consent renewals to function. So
Are you arguing that you had a legitimate expectation that the polluter pays principle won't apply? Is that your expectation?
Your Lordships, in the facts of the case, there is no
I know that. You said legitimate expectation. An expectation must be legitimate. You're a polluter. So are you saying that you expected that polluter pays principle won't be applied to you because they made a mistake in their show cause notice?
Your Lordships, in this case, we are not the polluter. We have merely not complied with pollution control measures.
You didn't have a consent. You didn't have a consent, right?
Yes, Your Lordships.
Therefore, you are a violator of the pollution laws.
Your Lordships, that is with regards to only the pollution control measures being in place because it is the mandate of the Act and not, Your Lordships, the compliance is with regards to it is mandated by the Water Act and Air Act for renewal of. Yes, Your Lordships. Not polluter, Your Lordships. We have merely violated. Violated. We are not going to dispute the fact that we have not violated.
Counsel, then if you're admitting you're a violator but not a polluter, as per the formula, there are 5 conditions under which compensation can be imposed on you. One of those conditions is for you to not have valid renewals of consent.
Indeed, yes, Your Lordships.
Then what is the problem?
But Your Lordships, that is with regards to the CPCB methodology. It has not been officially notified. However, it is not officially notified by the ministry, Your Lordships.
It is approved by a court order. It is by a court order upheld by the Supreme Court.
Your Lordships, in Paryavaran Suraksha Samiti case, that the council thinks that that is the
Yes.
Your Lordships, in Paryavaran Suraksha Samiti case, direction to CPCB for making a methodology was only initiated. That report was not reverted back to the Supreme Court for approval.
No. Supreme Court was originally dealing with that Paryavaran Samiksha case. Supreme Court transferred the litigation to the principal bench of NGT. Principal bench was continuing. Principal bench wanted a report from the CPCB. CPCB placed the report before the principal bench and principal bench approved the report and made the order directing the authorities to enforce the report.
However, Your Lordships, if we look at the contention is that we are
My
violators.
question was, your whole argument is, I did not pollute, but I am a violator. My question is, leave aside the fact for a moment, whether or not you're a polluter. If you are a violator, under the formula, you are liable to pay environmental compensation.
The council would like to state that as because the concept of violation is being dealt in section 44 of Water Act, penalties have been levied in case the particular person or industry, they do not comply with the consent renewal orders or with regards to any conditions that has been laid with regards to consent renewals, they will be penalized according to section 44 of the Water Act.
No, section
not
44
through
is
levying
section
environmental
44 is not
compensation.
monetary. Section 44 is imprisonment. So the
I'm fine, Your Lordship.
consequence, yes, and or the consequences, if you do not obtain consent, you are liable for imprisonment by criminal trial. You are liable for compensation for the civil damage.
Your Lordship, there is no civil damage in this case is what is being contended, Your Lordships. Just because we did not have proper consent renewal orders will not make us polluters, Your Lordships. It is like irrelevant. Your Lordships, the council is currently dealing with issue 2 in hand. Your Lordship, the council believes that the council has almost covered everything that the council wanted to say before the bench. If any other questions regarding issue 2 or Your Lordship, this might be misplaced, but the council believes that the facts of the case is very clear. Can the council refer to the notes, Your Lordship? Your Lordships, in this case, as the counsel for the respondents, the doctrine of legitimation was invoked because when initially the show cause notices was given, it was given to two different parties. Not only to the industries, it was also given to the district administration for sewage pollution, and for us to not renewing consent orders, and with regards to CETPs and SETPs. Here, if the pollution control authority can directly levy environmental compensation on the district administration.
That is because of the problem of identification. If municipal sewage is mixing with river, the only person responsible is the municipality. There is no doubt. So that I can issue an order straight away. If there is industrial pollution, I have to find out which is the industry.
Your Lordships, but that will be dealt by my co-counsel. That is why the principle of natural justice is being violated here, because in OA number 7 of 2021, which has triggered this course of action, we were not made parties to it. Even though, as the opponents have stated that they have given us separate tables with how the environmental compensation was derived, the report was not given to us, which is mandated under section 22 of the Water Act. If there is a sample effluent test that is being undertaken by the boards or any other person associated with the board under section 22, they must give such a report copy. The copy of at least one copy of the report must be given to us.
So in your show cause reply, did you adduce contrary evidence to show that there is no pollution?
Your Lordships.
And my last question is, under the what is the principle of law? Where is the burden of proof insofar as environmental pollution? Is it the duty of the Pollution Control Board to prove pollution, or is it the duty of the industry to disprove pollution? Where is the burden of proof?
Indeed, yes, Your Lordships. In environmental protection, the burden of proof shifts to the respondents to disprove the pollution in this matter, and that will be dealt by my co-counsel, answering issues 3 and 4. Much obliged, Your Lordships.
The council seeks permission to begin. Much obliged, Your Lordships. The council seeks permission to move on with issue 3 in hand. Much obliged, Your Lordships. Issue 3 in hand is concerned on whether the imposition of environmental compensation by the Pollution Control Board based on the CPCB methodology in view of Section 15 of the NGT Act and on the Jan Vishwas Act 2023. The council humbly submits that the Pollution Control Board have ventured into a territory that the constitution and the parliament never permitted them to occupy. Would have this court believe that through mere methodology, that is the CPCB methodology, compensation can be extracted from the industries. But law is not so fragile and nor justice is so expendable, your lordships. Because firstly, section 15 of the NGT Act, which is concerned about deliberating the vesting of exclusive power, that is, your lordships, the council begins with section 15 of the NGT Act again, which it is a complete code in itself, and it empowers the tribunal and the tribunal alone to provide relief, compensation and restitution to the victims of pollution and to order restoration of the environment. So, your lordships, it is important to interpret the legislative intent behind the establishment of the NGT Act. So, speaking of why did the parliament establish the NGT Act, it is because adjudicating environmental compensation and the environmental disputes require a judicial oversight and a technical expertise and not administrative dictates. So the state pollution control boards was created as regulators and not as adjudicators. So their role is preventive and not punitive in nature, your lordships. Therefore, and also their role is supervisory in nature and not judicial in nature. So at this point, the doctrine of occupied field would apply because it squarely applies because when Parliament vests adjudication power or when the Parliament vests jurisdiction in the specialized tribunal, administrative authorities cannot run a parallel system. So to allow the state pollution control boards to impose compensation on the basis of CPCB methodology, it would be to create two parallel adjudicating mechanisms at the same time. One will be grounded in statutory mandate and the another will be grounded in executive convenience. So in this way,
Council, can you refer to section 15 subclause 2?
Yes, your lordships.
You're saying the parliamentary intent is any amount for restitution should only be through the process and procedure of section 15. Please see section 15(2). There are some exemptions.
In 15 clause 2, your lordships, it is said that the relief and compensation and restitution of property and environment referred to in clause A, clause B and clause C of subsection 1 shall be in addition to the relief paid or payable under the paid or payable under the Public Liability Insurance Act 1991.
So section 15 is not occupied.
Your lordships, again, even in the subclause 2, it is given or it is established with respect to the of the entity. Only during the exercise
No.
of the power of
Section 15 power is in addition to whatever is there under the other act. It is not the sole repository of the power.
Your lordship, even if, in this case, even if the Public Liability Insurance Act is involved, your lordships, if in case it is as very well established by my co-counsel, if it was the intent of the Parliament to provide the pollution control boards with the power to adjudicate or to levy compensation, they would have very well done so by amending the acts and by giving them the express statutory provisions. But they did not do so, and also the doctrine of expressio unius est expressio ulterius applies here because it is expressly mentioned that the NGT has the power. And at this situation, it can.
But how do you answer the question by lordships earlier? Even if the Parliament does not expressly given a power to impose compensation, once this has been given by an order of the court, and that order of the Honorable NGT or the Honorable Supreme Court is not disturbed till later. What is your answer to the precedent of the court empowering in the absence of a law? Can the court, by order, direct for certain principles to be in place to ensure justice?
Your lordship, the court can establish orders in order to.
So the court has given this form. My question is this: if the Parliament does not expressly given, there is no prohibition for. The court has stepped. If the court has stepped into an area where the Parliament has not legislated, and Parliament has not said in the negative, both cannot. So an area where the Parliament has not directly legislated, if the court in the interim has laid down certain measures, isn't that valid? And this is the Supreme Court which has laid down.
Your lordship, firstly, it has to be noted that the council accepts that it is the Supreme Court which has laid down this mechanism, your lordships, under the Paryavaran Suraksha Samiti case. But as already established, it is important to note that the order of Paryavaran Suraksha Samiti case is not binding before this honorable bench because that judge has come from a lower bench, your lordships. It constitutes of a three judge bench.
The judgment is not even challenged. Then you should have challenged the judgment. That judgment not as true. But why are we on the binding aspect? That is not challenged. That is settled law. Nobody has questioned it. You have not questioned it.
Your Lordship, the binding nature of the Paryavaran Suraksha Samiti case may not be questioned directly.
So while dealing with the question on section 15, you want us to relook Paryavaran order?
Your Lordship, it is the question in hand is that the power to levy compensation or the CPCP methodology, all these concepts have flowed from the Paryavaran Suraksha Samiti case judgment, which was followed by the NGT, whereby the CPCP methodology was established. So in that situation, since all these concepts have derived from the Paryavaran Suraksha Samiti case, and the same CPCP methodology and the power of Pollution Control Board to levy environmental compensation is the question of law at this juncture, Your Lordship. So since that is the question of law, it has to be very well noted that the particular judgment given by the Paryavaran Suraksha Samiti case may be followed by the NGT because it is binding. But when the question of law is before the higher bench now, it is in the hands of the higher bench.
No. I think you misunderstood. I'm just going to. I think the question which is calling for you is this. You're right. The Constitution bench, and as a precedent, the earlier bench decision not bind us. You're right. The earlier bench's directions are issued under Article 140. Means that in the absence of what the court felt to be a vacuum, it issued certain directions. Those directions have manifested themselves from the CPCB formula. The formula has been placed before the principal bench. The principal bench has affixed a seal of approval to it. Now, if you're going to say to us that that entire structure should be dismantled, you should argue as to why those 140 directions are bad. You can't simply say it's not binding on you because you're a larger bench. No, we are not looking at it as a precedent. We are looking at it as an earlier set of directions issued by the Supreme Court.
Your Lordship, even on that aspect, when we are talking of the CPCB methodology, it was devised under it is an entire methodology or set of directions that was followed under the directions given by the Paryavaran Suraksha Samiti case by the Honorable Supreme Court. And even in that case, the CPCB methodology is not still officially notified by the Ministry, Your Lordships. So until it is officially notified through any through any subordinate legislation or office memorandum or a proper notification, only in that situation the CPCB methodology can be officially used, Your Lordship. And also, it is very important to note that the CPCB methodology itself, in its entire report, to be particular.
And under which provision of law should this have been notified according to you?
Your Lordship, the CPCB methodology was devised under the judicial.
Which provision should it have been notified? And in what way you are affected because it is not notified?
Because, Your Lordship, in the recent case of DPCC, as it was stated by the opponents itself, in the case of DPCC versus Lodi property, it was said that it requires a subordinate legislation in order to execute the powers of pollution control board.
Well, that's for 33A and 31A because it's a statutory power. Now, this is a formula given by the court.
Your Lordship, a formula that too, when it is concerned with pecuniary charges, it cannot be levied without a proper statutory backing or without.
That is what I'm asking. What statutory procedure should have been followed?
Your Lordship, it must be formally. The council is not able to pinpoint a particular section, but even if the NGT is applying the CPCB methodology, while adjudicating, that is under section 15, it might have approved it. But that has not happened here, Your Lordship. Rather, the NGT has only referred to the
Forget the NGT.
Counsel, I just have a question. So with respect to we're talking about the Jan Viswas Act, right?
Yes.
So in the Jan Viswas Act, so your main argument is the Pollution Control Board cannot levy environmental compensation, right? So let us talk a little bit now. As far as the Jan Viswas Act is concerned, you would have seen that the intent of the legislation is to levy penalties, right? So there is a legislative intent to levy the penalty, so it can also encompass compensation also.
Your Lordship, in that aspect, the Jan Viswas Act, Your Lordship, the council understands the question that Jan Viswas Act or it purports to decriminalize certain provisions and to reduce the burden of the companies and to make it easier for them to run their business or so on, Your Lordships. So that is the entire objective of the Jan Viswas Act. It purports to do so. So in this case, when decriminalizations are happening, when monetary liabilities are reduced by
There
the
is a legislative intent to, let us say, to occupy the field of monetary sanctions, right? So why can't that encompass environmental compensation as well?
that is the exact contention of us, your lordships, because the Janvishwas Act intends to reduce the monetary liability and also to occupy the field of the monetary liability, your lordships. In that situation, if the pollution control boards have used its inherent powers in both section 41 and 44 of the Water Act, it could have levied on us for not obtaining consent or for not obtaining renewal. But the Pollution Control Board did not use their inherent powers or the statutory powers under these sections, and they did not levy as penalty. And it is also important to know that if penalty was imposed, it would have been a lesser monetary liability on us. But in this situation, 50 crores is levied on us, and 50 crores, and it is true that the 50 crores was levied on us with respect to for each units, that is for each
Counsel.
for units.
Have you challenged the notification of the CPCB in the present litigation?
Your Lordship, the levying of environmental compensation, which is based on the CPCB methodology, it is
Unless you challenge the methodology of CPCB specifically, can you argue that a subordinate legislation or formula arrived at by a statutory body is bad in law? Because I don't see a prayer which requires the cancellation or nullification of the formula arrived at by the CPCB. When you have not challenged the formula per se, can you challenge the applicability of the formula alone?
Your Lordship, the CPCB methodology is not directly challenged here, but basing the environmental compensations on the CPCB methodology, which is a mere formula, not a statutory authority, is the exact contention which is held under issue 3, your Lordships. So under issue 3, the entire issue is concerned about whether the environmental compensation levied by the PCBs can be based on this methodology. So our contention is that it cannot be based on the in that methodology, because how weak the applicability of the methodology is, because it is not a statutory provision, your lordships, and also it is not a statutory authority with respect to pecuniary charges. As already held, for pecuniary charges there must be a statutory backing, your lordships. But CPCB methodology is just a mere formula, and it is not a complete statute or code which is authorized, your lordships. Much obliged, lordship. So as the council was contending, the CPCB methodology is again, it's a guideline and it's not a law. And also it can be agreed that it is at its best is a set of administrative guidelines which is meant to assess the NGT in quantification when the tribunal is already seized of its jurisdiction under section 15. But the pollution control boards cannot derive its power directly from the CPCB methodology for that per se. And also it is important to note that CPCB methodology itself in its report has clearly mentioned that environmental compensation is not a substitute for establishment of the penalties or for the establishment of the already existing powers under the Water Act and Air Act. The CPCB methodology itself says that environmental compensation is not a substitute for the establishment of or for the application of these statutory provisions. And also the CPCB methodology in its language, if we could see the language of the CPCB methodology, throughout the methodology it is given that this methodology may be used, this methodology may be utilized, this particular scheme may be used. So this is the exact language of the CPCB methodology. Situation, the methodology itself in its own language agrees that it is not yet approved or it is not yet statutorily backed, your lordships. So that is the argument with respect to the CPCB methodology. And moving on to the aspect of natural justice, now let us assume, your lordships, for the argument.
Sorry, before that I have a question. If you go through the fact, take paragraph 24. Since you're talking about the quantification, Bhakti Corporation challenged PCB's order before the NGT North Zone, right?
Indeed, yes, your lordship.
And against that, you went to the High Court and you won in the High Court, so you're a respondent here. How did you go to the High Court against the NGT's order?
Your lordships, because
Under which provision of law?
your lordship, under 226.
Isn't there a statutory appeal to the Supreme Court, to this court? How did you go to the High Court?
If the orders of the NGT is agreed by the person, it can come to the Supreme Court under Section 22, Your Lordships.
Right.
But this was gone to the Honorable High Court by the sanctions of 226, Your Lordships.
Don't you think
Your Lordships, is the question with respect to...
How did you bypass section 22 and went to 226?
It is an alternative...
Unless a constitutional violation. Because 226 is a constitutional court, you know. If there
Yes,
is a
Your
constitutional violation, you can go by way of petition. But if it is a substantial appeal under the National Green Tribunal Act, under the Environmental Protection Act, then the environmental jurisdiction expects you to go on appeal. That appeal to Supreme Court is on substantial question of law alone, under 22. And that appeal will not be admitted for any other reason. Supreme Court has framed the substantial question of law.
you are talking about Article 226? You are aware that if there's an alternate remedy, then the High Court is expected not to exercise jurisdiction, correct? So how did you are now answering their appeal? So why should they not argue that the High Court should not have exercised jurisdiction at all? My question.
Your Lordship, can you just...
How was the proceedings before the High Court maintainable? Is the
Can I
question we're asking.
just add to what my learned friend said? Maybe I'll be able to explain. See, the Act is very clear. If there is any order that is passed by the NGT which is not satisfactory, the statutory appeal will only lie to the Supreme Court under 22 of that. Correct?
Indeed.
So, in case you had to go before the High Court, there has to be a constitutional violation for 226 to be invoked. What is the constitutional violation in this particular order empowered you to go to the High Court rather than take it by way of a regular appeal to the Supreme Court? Can you bypass the appeal provision under the Section 22, particularly when it lies before the Supreme Court, and move the High Court, which is of which does not have the jurisdiction to deal with the issue per se?
Your Lordship, the first thing is that... Your Lordship, the first thing is that the fundamental issue that was involved in order to go to the High Court, the fundamental rights concept which is involved here is arbitrariness. Because when the pollution control boards have levied the compensation, again based on the CPCP methodology and also without a direct proof, and also as established by my co-counsel under Section 22 of the Water Act, it is mandated for the pollution control boards or any expert committee to give a copy of their report to us, and that was not furnished here. And also we were not given a chance to express our stance. So therefore, firstly, the principle of natural justice was violated here, because the principle of natural justice is not a box ticking ritual. Just because they have given us a show cause notice and have allowed us to reply, that doesn't mean an entire NGT proceeding or an adjudicatory proceeding has taken place. So firstly, we were not heard of our... So natural justice was violated here. Secondly, arbitrariness is there because one, there must be an intelligible differential and also a racial nexus with respect to the orders passed. And in this situation, firstly, there is no direct proof or there is no unit specific proof that was... Only tables was given to us with respect to how the PCB formula has worked. So with that table, we cannot take that we have got the entire proof.
Counsel, before the NGT, you were the appellant. What do you say that you were not heard? You were the appellant before the NGT, you lost the appeal.
Your Lordship, the counsel is trying to say that the High Court has accepted the appeal.
The High Court, you filed a writ petition challenging the order of the NGT. Is that correct?
Indeed, yes, Your Lordship.
And before the NGT, you were the appellant. It
Yes,
was
Your
your case before the NGT.
Yes, Your Lordship.
NGT heard you. And NGT made an order. Right or wrong?
Yes, Your Lordship.
Where is natural justice to go to High Court?
Your Lordship, when talking of why the fundamental rights concept and the fundamental right violation has happened here, the counsel is trying to say under Article 14 the arbitrariness and also
The fundamental, by the Pollution Control Board, if you say that there was a fundamental right violation, if you had challenged the Pollution Control Board's order under 226 to say there was a fundamental right violation, that's a different case. This is the Pollution Control Board made an order. You filed an appeal against the Pollution Control Board order before the NGT. You were the appellant. The appeal was dismissed. As against which you went to High Court. You're saying the NGT did not hear you when you were the appellant?
Indeed, no, Your
Lordship. Then why not the 22 appeal?
It is because the NGT has dismissed our appeal.
Correct.
whereby the appeal was with respect to how the TNPCB, sorry, the Madhya Pradesh Pollution Control have not given us a proper chance to express our stance.
Can you not raise that as a ground under section 22? Are you prohibited from raising that the NGT did not hear this in the proper legal background? It's a ground for appeal.
So, Lordships, but it is also to be noted that our appeal was accepted in the High Court and there it was heard, and only after that it has now come to the Supreme Court through the SLP, Your Lordships.
So can we not today say that the writ petition itself was not maintainable? We are going into that. You should have filed an appeal.
Your Lordship, it has come to the Supreme Court now not through writ petition but through civil appeal, Your Lordships.
You are convenient. No, you're being a respondent and convenient.
Regarding the maintainability issue, Your Lordships. Please, Your Lordship. So, as I was saying about the
As final court, we are asking you, why you go to High Court by way of writ petition? You should have straight away come to us under 22. Why did you go to High Court and suffer a judgment?
Your Lordship, when there is an it is not prohibited in law to go to the to follow the proper hierarchy of the courts, Your Lordships. So.
You can't go under 2.6 when the available. That was my question. But you time on this, move to
Your Lordship, the right to legal remedy that we have allows us to do so.
Legal remedy is 22 to come before us.
But that does not prohibit us from going to the High Court, Your Lordships.
Okay, fine.
Sorry, Your Lordship. Further, Your Lordship, speaking of the concept of natural justice, it is also to be noted that when the show cause notice, Your Lordship. Lordships, issue 4 in hand deals with whether the units of MS Makti Corporation and Kia are liable to pay environmental compensation in the absence of direct proof of pollution being caused by them, and whether the orders of both the state pollution control boards and the state pollution control boards are correct, and also whether the orders of the Madhya Pradesh High Court and the NGT South Zone bench are liable to be set aside. The first contention is that, Your Lordships, the most fundamental premise of any monetary compensation is causation. The law, it is to be noted that the law does not permit mere suspicion, but it requires and it does not permit mere suspicion, statistical probability or aggregated committee reports to crystallize into enforceable liabilities. And also,
it does in environmental jurisprudence. Like they relied on the absolute liability principle in environmental jurisprudence. If you are dealing with effluents, and if you are next to the water body, and if the water body is polluted by effluent, and if you are the proximate cause, you are liable.
Your Lordships.
How do you get over Electrosteel's case? Electrosteel's case makes it very clear that there is no direct proof required. I'm just adding on to what my friend has said. It is made clear that if there is a proximity and if there is a possibility, you can be penalized. There is direct.
Your Lordships, in the case of AP Control Board versus MV Naidu, what happened was the compensation and the penalty was levied without waiting for the direct compensation. But in that case, the court has held that it cannot be done with the probabilities or mere suspicion, and they requires.
Can you give me the citation of that judgment?
The citation is 1999 to SEC 718, Your Lordship.
2023 is Electrosteel. So this is virtually overruled. How do you overcome that?
Your Lordships. Your Lordships, that particular case is not present in the company. Your Lordships, when speaking of that, even if direct proof of causation is not required, in that situation, if there is no need of direct proof of if there is no need of letting us know if there is no need for calculating the proof or calculating the evidence for each particular effluent discharge, in that situation, the Section 22 of Water Act would not have mandated, and again Section 21 of the Water Act also mandates that whenever an analysis happens with regards to effluent discharge, whenever sampling is taken, the Section 21 lays down an entire procedure through which the sampling or through which taking samples.
So the sampling was done of the river. Why should you be put on notice for sampling the river?
Your Lordships, I am speaking of how the procedure of sampling should be taken
From
place.
your premises. Section 22 is, if I am taking a sample from your premises, I should follow the procedure.
Your Lordship, it deals with rivers and it deals with water pollution. In this current case,
You're saying the procedure of sampling was not followed, correct?
no, Your Lordships, the contention is that in section that is the council is speaking of the intention of section 21 and 22, Your Lordships. When speaking of the intention of both the sections,
Council, in your premises, if I'm alleging your treatment system is not working properly, if I want to take a sample from your treatment system or the pit or the dug well, etc., I have to put you on notice, give you a sample, treat in a sample, etc. I am taking a sample from a public river. Who should I put on notice?
Your Lordship, the content is that whenever the section 22 states that whenever an analysis report is formed against any person who is violating, or against any person or agent who is violating, a copy of the report must be given to that particular person. Your Lordship, that is why the council is trying to invoke section 22, and also as per the fact matrix, we have not received any such report, any such copy of report, Your Lordships.
So your argument is the river is not polluted.
Indeed, no, Your Lordships. It is the council is trying to make a point that it is the intention of the legislation themselves. It is the intention of the legislation themselves that a copy of the report must be given to the polluter or the violator.
Copy of the report, the intention of legislation is, if I am taking it from your premise, I should give you a copy of the report. That is the legislative intent.
Exactly, Your Lordships. The council is
Unless you are saying the river is not polluted, the very evidence that the river is polluted is erroneous. If I had been given a copy of the report, I would have contested to say that it is a false report. The river is pristine. Then we understand where your argument is going. You're saying the river is polluted.
Your
You're only,
Lordships.
then isn't it hyper technical once you're admitting the river is polluted? What are we trying to prove? What is the culmination of your argument?
Your Lordship, the contention is that
No, would your argument be any different had the report been furnished to you and the report still says the river is polluted? How different will your argument be?
Your Lordship, that is why the entire section 3 dealt with how the report is being furnished and what methodology that your report is being based on. So again, even firstly, report has to be furnished, and secondly, even if the report is being furnished, it has to be noted that on what methodology the report is being based on. So, indeed, yes, Your Lordship. Indeed, yes, Your Lordship. Your Lordship, in this instant case, the contention is not that we are not aware of the pollution. Rather, the contention is even more specific that pollution was the Keeladi Industrial Association units denies that we have created pollution. In the reply notice that we have given to the Your Lordships, it is important to note that the entire environmental compensation was levied to us from the period of when the Joint Technical Committee report was established till the compliance was achieved. And and for the compliance of the pollution control norms, it is the Pollution Control Board who has accepted our reasons and has given us extensions continuously. Your Lordships may wrap up the honor. Much obliged. So it is the Pollution Control Board who has given us extension to fulfill the compliances, and compliances, as mentioned by your Lordships, is done under the supervision of the pollution control boards. And also it is important to note that in this case we agree that we have violated the particular thing, which is we have not obtained consent or we have not renewed consents. So in this situation, it is important to note that while we don't have consents or while we have not renewed our consents, we cannot even function and we cannot even operate, which would be illegal in law. So,
That is squarely the key reason for the Pollution Control Board to say, without consent you are operating. See, end of the day, you are all in the upstream. 250 industrial units are discharging effluents and downstream water, and sample is taken, and TDS is very high and very heinous and dangerous. And how to put an end to this environmental disaster? Can you say that I have not been given opportunity, but still I will discharge effluent? Without consent, I will go on conducting my industry. And if should not do any action.
Your Lordship, the contention is that as we have the councils and the respondents agree that we have not obtained consents and renewals, and we have applied for the same, and during the compliance period the approval process were taken up. So the approval process for the consent and renewal were going on during the compliance period. And it is important to know that, as mentioned already, if we do not have consents, or if we have not renewed our consents during that time period, we are not allowed to operate. While we are not even operating, how would we have polluted, your Lordships?
How do you say you are not operating? Paragraph 17 says you are operating.
Your Lordships, that is with respect to that particular thing is with respect to after the COVID pandemic time. And after that only the inspection was given, has been taken, and after that notices was
It is a compliment to you. Bad case argued very well.
Your Lordships, if may move on with the prayer, Lordships. Much obliged. Much obliged.
With the permission of the bench, Your Lordship, the council like to humbly submit. As our friendly councils have stated, it's very questionable why they want to put penalty on them, imprisonment on them, illegality on them, where here it's mere restitution that has been placed on them. Our learned friends have stated that as per the Learned Council 1, stated while giving show cause notice in itself, we should have placed the compensation. Your Lordships, that was the... Your Lordship, that was in the furtherance, Your Lordships. They in the primary show cause notice.
Until the NGT asked, you had no intention of imposing environmental compensation. Merely because the NGT asked, you went and levied some compensation.
Your Lordship, isn't that supporting us? We are not trying to.
Why did you not impose compensation? If you are so worried about the pollution and if you want to restore the environment, you should have done it on your own.
Your Lordship, the council like to substantiate.
Their argument is, you did the whole environmental compensation imposition only to save your skin before the NGT.
Your Lordship, the council summons firstly, when giving the first show cause notice, they did not have consent. Without consent, how do we know what is that industry, what is it doing? Indeed, Your Lordship, they demand closure, which is very suspicious.
Can you tell me what is the connection between consent and assessment of environmental pollution compensation?
Your Lordships, they do not have the power to run in itself. The first show cause notice was given for closure. However, the defense that they took, SPCB was very consistent.
Tell me under what provision of law you have the power to expand your own show cause notice?
Your Lordships, they demanded some time period for setting up the consent and renewals, and understanding COVID-19 was very unprecedented to all of us.
No, council under law, if the statute mandates you to do certain things in a particular way, you can do it in a particular way. So, show cause notice has been issued to you by you as per the provisions of Air and Water Act. Once the show cause notice has been issued and that has been complied with by the authority, what is your further power to impose environmental compensation. Where do you draw such a power?
In your lordship, that is from, as the learned friends have very well agreed with this, there should have been a judicial oversight for such things should be placed, for compensation to be placed. We were indeed trying for when the NGT has a judicial body, has given us that power, has directed us that power, then after we went and claimed. So in fact, we are on the right side. Maybe initially, before the NGT, before everything, before knowing what is the consent and renewals, before knowing the show cause in itself is an evidence that we were willing to hear. Before doing all of these things, if that time if we place compensation as the learned friends wanted to, which is very questionable, that time if we place, they can say arbitrary, nobody asked our hearings, our stance was not heard. But after all the show cause notices were issued, after all the procedures were followed, now placing compensation, they're questionable and they're saying penalty should have been placed, imprisonment should have been placed, illegality is on our side. We are happy that they've agreed they're illegal to work. Maybe we should restrict them further. But your lordships, that is the council stance. If before as they asked, that is correct. But now after the procedure has been complied, it is now they're coming up with this issue that you should have closed it in the first itself. We are illegal. Please don't let us practice, which is very questionable as the learned friends have contended. Raising the first question of rebuttals, your lordship, they have relied on 15th Amendment and which talks about binding, does not talk about binding nature of High Court, but filing nature. Your lordship, where you can file the jurisdiction is what Kusum ignores, and every other 15th Amendment is talking with 1 minute permission, your lordships, is talking. And they have misled the bench by stating DPCC versus Lodi property is irrelevant because there is no subordinate legislation. But there is no restrictions on Air Act, Water Act, Environmental Protection Act or anything towards compensatory nature. There is no restriction that has been placed. And we cannot say a similar factual matrix in front of the Supreme Court, though it was with a lesser division, is irrelevant and bad in law. Your lordships, the learned friends have stated that in NGT Act has the power. SPCB does not have power. It is NGT
Council,
Act
your
sole
time is
power.
up long before you did not take the leave of the court to continue further.
The council had asked lordships. The council, your lordship, much obliged, your lordship. The council would like to conclude by stating that they agreed if NGT would have asked them compensation, they would have paid. But if NGT is directing somebody to go ask compensation, they will not pay, which is again very questionable, your lordship. What the council is not able to understand what the learned friends are trying to say, that they are illegal, they are wrong, they need penalty. NGT can give, but SPCB cannot give just because direction has taken place, which we substantiated. Direction can be taken place through multiple provisions in case laws. In your lordships. Your lordship, SPCB is not powerless, your lordship. The SPCB has under the direction. That is how the council did not, the council's client initially go and claim compensation. They waited for NGT. As stated in AK Kripak, delegations can be done, your lordships. Much obliged, your lordships. It was a great honor arguing before
I understand your trouble.
Much obliged, your lordship.
You should give a copy to the other side. I mean, that's what you should learn. Give a copy.
Much obliged, your lordship. Your lordships, it is not in the memorial, but this is to answer the rebuttal question that was posed by my friendly counsel. Only to substantiate the same, the council is submitting that document, your lordships. Your lordships, the council will be only dealing with why penalties because it is so questionable. A simple calculation, your lordships, 50 crore divided by 234 industries is 21 lakhs on each industries. And we must note that the 234 industries is comprising of red industries, that is the highly polluting industries, as well as the orange industries.
The fact say it's divided equally?
No, your lordships. I'm merely just to put an illustration. Indeed, yes, your lordships. Indeed, yes, your lordships. That is the very contention, your lordships. Even if it was to be equally divided in a case, for an example, it amounts to 21 lakh on a particular industry. for each industry in the
21
230.
lakhs on each industry for not taking consent. The uniformity is that you're not taken consent. We are applying that homogeneous formula because of your violation, basic violation. We are not concerned about the second step of how much pollution was happening because of each unit. We say none of you took permission. We are apportioning the fine among all of you.
Indeed, yes, your lordships, but as industries, as opposed to 21 lakhs, 10,000 rupees fine or a penalty seems feasible for us because we need to do business.
You should have thought of it before operating the unit.
That protects our rights under Article 19, Clause 1, Clause G. So if it is a penalty, it is much lesser because we have already, compliance is mandatory, your
You're
lordships.
seeking a lesser sentence now. You're seeking a lesser sentence now.
Penalty up to 15 lakhs, right? Lowest is 10. Maximum up to 15 lakhs.
Water Act for not getting consent from the boards, your lordships, under 40, section 41 and 44. The council is merely stating as, because the opponent council has stated, it is so questionable. 10,000 as opposed to 21 lakhs is much better when it is an industry that is in place. No, that is not the contention, your lordships, because we have not polluted, we have merely violated a norm that was to be undertaken. We have not caused violation. That is indeed, yes, your lordships, because when that was the contention of the industries in the show cause notice reply, and the TNPCB has accepted if they wanted
Is
to.
TNPCB a party here?
Yes, your lordships, that they are the appellants in this instant matter. So if the reply that was given by us was so was not accepted,
Your liability was not only that you did not have a consent renewal.
so with regards to not having proper pollution control.
What else do you require? You did not have, you are an industry generating trade effluent. You did not have a treatment plant. You are proximate to the river. River is polluted. You did not have a consent. You admittedly did not have a proper treatment mechanism.
Indeed, yes.
What else is
But
required?
as your lordships have, as your lordships have correctly pointed out, there is a chance that we might have stored the effluents and not let it into the
Very
river.
well, there might
And
be a
there was
chance.
no hearing for that matter in OA number 7 of 2021. They did not give us.
Percolation.
Your lordships, if it was the case of groundwater pollution, then the formula that was contended by my friendly councils would not apply. Yes, your lordships, because the lordships has questioned the council with regards to groundwater. If that was the case, then in the report of CPCB methodology, the first formula will not apply. And there is a separate formula for groundwater. That is the very contention, your lordships. Much obliged, your lordship. Much obliged, your lordship.
Both the teams have done wonderfully well. We are very happy with the outcome. We are actually very, very happy with the preparation levels.
I've judged, sit down, sir, please sit down. I've judged just up the international round quite a few times, and there's a practice of giving feedback. So just in the sense of being constructive. So let's talk about each one. Team 1, speaker 1, the freedom with which you spoke during the rebuttal, that should have been there in the opening. It was fantastic in rebuttal. but somehow in the opening you were a little bit more reserved. Just try to explore that thing. Okay, you did so well in rebuttal. Very, very well done. Don't stand up, please. It's all right. Speaker 2, great job. Your knowledge of facts was fantastic. Try to follow the line of questioning so that you don't wind up contradicting something you said in your memorial. Right? Otherwise, knowledge of facts, very good. Team 2, Speaker 1, superb. Just avoid these big phrases which trap you. And one more thing, I forgot your question, will lose you the round. I guarantee that. In Jessup, it's like the cardinal sin. They'll just stop it. No, don't say sorry. Telling you so you learn in future. Yeah. So with that, the round will stop. They won't ask you any more questions because it's seen as a disrespect to the judge. Speaker 2, keep your balance when questions are slightly off the thing come. Okay? Because they will come. You should have some kind of a way to answer something slightly off. Because if you let it fluster you, you have just about 10, 15 minutes to get back on track. And you take too long, then it will be a problem. That is very well done. Thank you.
One another suggestion to speaker one of the respondent thing. Never look at the judges and keep nodding as if you are in concurrence with your counsel. So given that you are in concurrence with the counsel, you did it at least 20 times. You are so excited that you turned around and kept nodding to us, asserting, I mean, like, you better accept what she's saying types. Okay, fair. It's a mannerism. Just don't do that. It's okay. The rebuttal was completely when you're ahead in the profession. The judges will tell you if you're ahead and the judges say you need not go, please sit down. Because you'll be doing more damage going there. You're not going to improve your case any further. Right? The way to do.
I request all the audience to kindly stay until the judges leave.